Sorry to interrupt. Is this Judge Hood's courtroom?
Yes, it is. This is Judge. APA Carr, are you checking in on specific cases?
Yes, Mr. Haywood. That's the only one I'm here for.
Aaron, is that something that got added?
Yeah, I didn't see it on the docket.
What's the case number?
97-500-792.
500. $97,500,792.
Correct.
Circle down.
So this is a juvenile lifer case?
It's a Miller case, and we're here on an emergency bond motion.
Okay.
That's on a juvenile?
Yeah, juvenile lifer.
Yeah.
Yeah, I was convicted as a
I
juvenile.
haven't heard nothing from Mr. Dawson. Dawson is the prosecutor on that.
Yeah, Mr. Dawson thought he was going to be in a hearing that ended up getting moved around a little bit, but I'm going to be doing it.
Oh, okay, you're doing it.
I'm doing it for Tom.
Now we have not writted Mr. Haywood for today. So I'll cover that with the defense attorney when she gets on.
Okay.
Karen Dongo.
Yeah, I see it.
Yeah. Okay, thank you, Mr. Carr.
Okay.
Yeah.
Mr. Schloff, which case are you checking in on?
And good afternoon, Judge. I'm here on Mr. Tavian Tate. And good afternoon, Mr. Plumpy.
Yeah, how you doing?
I'm grand, and yourself?
Doing good. Never been better.
I see my buddy Darren Gilbert. Darren there. Darren, how are you?
Yeah. Mr. Schloff, how are you?
I'm good, thank you.
Good, good.
I had actually nothing up this morning. I was able to relax, drink my coffee, read my paper out in the sunshine. It's been a great day.
How good is that?
I might get used to this. I might have to retire.
And make sure that you do everything on Zoom, huh?
That's not a bad thing. Now, Plumpy, he's going to be going on until the end of his days. He's going to be the next Joe Latomsky.
That's not true.
Darren, you remember Joe, don't you?
Yep. Oh, shoot. Take. Got 5 minutes. I gotta go. Oh, I got tape. Wow.
Good afternoon, Darren. This is Agent Graham from MDLC checking in for your violators if you have any MDLC matters.
Okay. They showed Norbert, they sent me a warrant on Jones.
Thanks. I'm gonna call over. Oh, yeah. All right, thanks. All right, bye.
Darren, I couldn't hear you because the jail isn't muted.
Yeah, I had a warrant was sent to me on Norbert Jones, I think it was. Had a bunch of warrants. Somebody sent me some warrants.
It should be
hold
from
on.
Agent Petty.
Yeah, I'm trying to find it. Send it on my different email. Oh. Oh, shoot. Okay, do you have Norbert Jones?
Yes, I
You
have
anything on Norbert Jones?
I have a warrant.
Okay, he was arraigned on the warrant.
Okay,
Set hearing, and then yesterday, Judge Thomas Hathaway capiacy on that case. And then we have him on a capias from a calendar conference. So, I mean, but that is what happened. I went down there to got the file, and they capiacy yesterday.
yeah, she may have
But
sent over warrants for things that have already been arraigned just because the judge, just in case if the judge needed to see them. Because nothing on the docket is actually listed as a VOP. But
yeah, I know they listed. They don't even have him listed on that case. They have our case, capias case. They don't have the case that he's on violation to the Judge Thomas, which is 1885-98.
right, right.
On the list.
And that's how a few of them are, from what I remember. So she sent warrants over just in case if Judge Hood wanted to address or needed to address any of the violation matters.
We probably just gonna put this back on to Hathaway's docket. I don't know how to case it anyway.
And then there's
Custody.
one, Darren, for Nicholas Fleming.
Yeah, Nicholas Fleming is gonna, he had an arraignment today. That's Judge Lillard's arraignment, and he's gonna be put over to tomorrow on that case.
Okay, perfect.
Judge,
Say it one more time, I didn't hear you.
violation. They're gonna do both of them tomorrow.
Okay, perfect. So we won't, okay, perfect. Because there was a whole issue with that warrant not being signed and all, it was a mess.
Right, that's what, so they're gonna handle that tomorrow.
Okay, perfect. What about Shayoed?
Yeah, he's got 2 new cases and he's got the violation.
Right, so are we gonna arraign him on that warrant?
Yeah,
Okay.
because he's got 2 other cases that's up today.
Okay. And we also have James Hyde. They dealt with the 18 case earlier today on the big docket.
Yeah, that James Hyde, we have both of his cases on.
Darren, I think some paper might be covering your microphone or something because you keep going in and out.
I'm standing somewhere else. No, he's on the Swift Insure. He's in the Swift Insure program now. Hi.
Okay.
Hear me?
Yes. So would we be addressing the 16 docket or was it already addressed?
No, it wasn't addressed. John Mara, who's on the Swift Insure, he's going to be on the call. That's what he got put into a program. What we usually do, they have an agent for that program as well. And then I think Andrea can, I think we just let you guys know what is going on with the case too.
Okay. I emailed and advised her that he would be in court today as well.
Yeah, he will be. Yes.
Okay.
Absolutely right.
Okay. Okay. Thanks, Darren.
You're welcome.
Darren, I'm not trying to go out of order. This is Attorney Andrea Fanning. I just need to check in for my client. I don't know what the order or protocol is.
You're fine.
Excuse me?
Fine.
I have a Sharik Show.
Yep.
Okay, thank you.
Good afternoon, Darren. This is Maria Manarino.
Yeah. I can hear you.
Oh, okay. I have an arraignment on Nicholas Fleming.
That's going to be done tomorrow in front of Judge Lillard. That's her case.
Okay, so not being arraigned today.
Nope.
Okay, all right. I'll tell Mr. Fleming because he was gonna log on. Okay, thank you.
This ain't loud on YouTube. Hey, Derek, this is Ted Wallace. Can you hear me? Hello? Did I not do that?
Yeah.
Can I check in on Evan Pollock?
Yeah.
All right.
Hello, Darren. This is John Mara from Swift Insure.
Yeah.
Just checking in on James Hyde's case.
Case is he's got two.
Okay, yes, 2016 and 18.
Yeah. Yeah.
Hey, Darren, it's Andrea.
Yeah.
I have Jones and Anderson, or is Anderson rescheduled?
Anderson is up today.
Anderson is up today?
You talking about Demondo?
Yes.
Or Ryan? Or
Ryan.
I think it's two Andersons on my docket. Demondo Anderson
Yes.
and Ryan Anderson is actually, you talking about Demondo? That's
Yes.
Anderson you're talking about. Yeah, that's up today.
Okay, you know his PSI interview was done this morning.
He what?
His PSI was done this morning on his new case, but so you're saying him and Jones will be handled today? Anderson and Jones?
Yeah, we have to, because he's got a violate, we have to, well, they did the referral already. We don't have to do nothing but set it. What date do they have on there as the sentence? They just had it on our doc. So when will the pre be ready? Do you know when it'll be
They
ready?
have it to 8/27.
Okay,
So we're doing the 31st.
so we're gonna have to do it on the 31st.
Okay.
That's the next date that we have, that we,
Okay, so I'll put him down for 8/31, and we'll handle Jones today.
yeah, Norbert Jones.
Yes.
Okay, Norbert Jones, they caped him yesterday. and
Right, I
Judge
see he didn't appear. Right.
Yeah. Custody.
I had him Friday. Judge Edwards was very clear about him calling in at 1 o'clock Wednesday.
Yeah, I wondered, but the thing is, I'm wondering, did he get out? Because see, he has a cape, we have a capias from a calendar conference, so he might not have never got out to jail. He may have told him that, but I don't know if he did, but he probably didn't get out, because when they took care of the violation and they ran his lien, he would have had our capias warrant is in the lien. So he might not have never got out. He may have still been in the jail. And yesterday, when he case and they called it and he wasn't on the call, that probably was why. It's probably because he was still in custody. Because see, our capias is from January of 2017. I mean, January 17th of this year. And it was always in there. So he may not have never gotten out, but I'm not sure. But he may not have never gotten out. But we'll find out.
Okay.
Yeah.
Madam Clerk?
That's fine.
It's Mr. Clerk.
Aye. Oh.
To everyone joining the call for COVID docket D, we'll be starting in about 5 minutes. For Division 1 at the jail, who do you have there?
I have Philip Philemon.
Sorry, Mr. Margolis, we'll get to you in 1 second.
Okay, I
To
thought you
Wayne
were
County
asking.
Sheriff's Office, Division 1 at the jail. Who do you
Good
have there?
afternoon. Yeah, good afternoon. We have Ryan Anderson, our extradition hearing arranged.
Okay. We're waiting on our clerk to get back to the courtroom. Once he does, we'll handle Mr. Ryan Anderson's case first.
Thank you.
Thank you.
Just before you get started, this is Matthew Penny. I'm on Raymond Stewart. I just wanted to let you know that I'm bouncing between you and Judge Ramsey's docket, but I'll sit tight with you for a little while if that's okay.
Thanks for the heads up, Mr. Penny. Once we have a bead on which division Mr. Stewart is in, we'll go ahead and give you a heads up.
My name is
You and
Martin
Mr. Pompey.
Drexel.
Judge Mark Lakin here. Do you have Mr. Boykin's case?
Bear with me 1 second, Mr. Lakin.
That's Gregory Boykins.
Mr. Lakin, we should have Mr. Boykins today. We've got 2 participants from MDLC, starting with JCS hearings number 1. Can you please identify yourself?
Gregory Boykins.
Good afternoon, Mr. Boykins.
Good afternoon.
And for URF Video Room West, can you please identify yourself?
Lionel Haywood.
Good afternoon, Mr. Haywood.
Good afternoon.
And Your Honor, Cecilia Carandongo, I have Mr. Haywood. I don't know if it's possible for the court to put us in a breakout room at all.
Absolutely. Bear with me one second.
Thank you so much, Your Honor.
Mr. Lakin, do you need to speak with Mr. Boykin in the breakout room as well?
I don't need to speak with Mr. Boykin unless he wants to speak with me.
Yeah, just for a brief second, that's all.
Thank you.
Okay, folks, hold tight 1 second.
Oh, yeah, there you go, right there. Baby. Yeah.
Your Honor, Lori Dawson from the prosecutor's office. I can see and hear Mr. Haywood's breakout room.
The breakout rooms have.
I'm sorry, y'all.
1 second, 1 second, everyone. Okay.
Good morning, Your Honor. This is Lori Dawson from the prosecutor's office. I also work in the Juvenile Lifer Project. I'm here with attorney Stephen Carr on Lionel Haywood.
Okay, we've got Mr. Carr checked in and we'll check you in too.
Thank you, sir.
Your Honor, may I check in? I'm here on Jamie Williams. It's a bond motion. And you did get, last week when we said it, you asked for a financial statement and I did email that back and Mr. Flowers acknowledged that he got it. So it should be in the file.
Yes, we have the financial statement. Thank you.
Okay.
I have Demando Anderson for sentencing. And the pre-sentence investigation report, do you email that to me so I can talk to Mr. Anderson about it?
Mr. Kinney,
Yes.
It's my understanding. Mr. Kinney, it's my understanding that the pre-sentence investigation report is not completed yet. So we'll give you all a new date for sentencing, but I want to make sure that we go on the record for Mr. Anderson's case so he understands what his next date is.
Yes, sir. Yes, sir. Thank you.
Thank you, Your Honor.
And Your Honor, I have another matter in juvenile. Can I do that matter since I know that you have a couple things before me?
That's fine.
Thank you, Your Honor.
Your Honor.
Yes, Mr. Margolis.
On Philemon, I know we're waiting for him, but just to let the court know, he also has a PC hearing in Westland this afternoon that I got to handle for him too. So he's set for that at 2:30, a Zoom hearing on that in Westland. So I just wanted to make you aware of that. And I don't know if we're just going to get an updated pre-sentence report or are we going to use the old pre-sentence report. You know, there was a sentence agreement from last year that he skipped out on in this case. And then he picked up the Westland case.
Okay, bear with me, Mr. Margolis.
Sure. Thank you.
Mr. Margolis, give us the case that you're here on again.
Philip Philemon, Filimon.
But he can't be sentenced no one.
Mr. Margolis, what's the case number you have?
Yeah, it is, let me get that for you. Hold on. It's 19-006-002-01 FH.
Mr. Margolis, our records are showing that that's set for sentencing on August 27th in front of Judge Deborah Thomas.
Oh, they're gonna switch it to August 27th? Okay.
And
Okay,
it's in
so
front of-
should I just, I can't hear you. I'm on mute.
Mr. Margolis, it's in
Yes.
front of Judge Deborah Thomas.
At what time? At what time?
Our records are showing 9 a.m.
At
on
9
August
a.m.
27th.
Okay, do you have her Zoom number or?
No, I don't, and I can't get it for you right now, but it should be available on the court website.
Okay, thank you. Thank you very much. So I don't need to be on now.
No.
Okay, thank you very much, Judge. I appreciate you. Thank you. Be safe.
You too. Darren, I'm getting a delay on my Zoom. Give me 1 second just to make sure I've got everything straight.
Judge, this is Jail Division 3 checking in. I have Mr. Tate and Mr. Langford here.
And I'm the attorney for Tate. I'll be ready when you are.
Okay, thank you, Division 3. Okay.
There ain't nobody else on here that I should know about.
Do we have House Counsel on the line? We're gonna need to appoint extradition.
That Division 1 down there at the bottom, well, under the.
Division 1, 6th floor. That's on top. That's Anderson, Ryan Anderson, the extradition. And then below him is Tate in Division 3. We need to appoint someone to represent. Let me get the House Counsel list. Give me 1 second. For folks joining the 1 o'clock call, bear with us another 2 minutes. We need to get a few more things squared away. We'll start shortly. We have Ms. Soroki on the line. We have Pauline Soroki on the Zoom call. Okay. Darren, let me get Jason to give her a buzz. So they've got Tate.
Judge Hood, we're
Anderson.
back.
Okay, welcome back, Mr. Lakin. All right. So we can do, if Soroki doesn't join the call in a moment, we're going to appoint someone to represent Anderson. Yeah. Mr. Schloff, do you need to go into a breakout room with Mr. Tate?
No, sir, I'm ready when you are.
Okay. Mr. Tate in Division 3, can you hear us clearly?
Can I say yes?
Yes, sir.
Okay.
Good afternoon, Mr. Tate.
Good afternoon.
Mr. Keogh, are you going to be representing the people on Mr. Tate's case?
I am, Your Honor.
Okay. Bear with us 1 second, folks.
Sure, Judge.
Mr. Schloff, while we're waiting, do you have discovery on this matter?
No, I do not. That's one of the important things I was going to address with you today.
Perfect.
Okay. Darren, ready on tape.
Okay. Ms. Rose, are you ready?
I am.
Oh, I said Ms. Rose, the court reporter.
Yes, I'm ready.
Great.
Here we go. This is case number 20-2663, People State of Michigan versus Tavian Tate. He's here on the docket conference, Your Honor.
Can the parties identify themselves for the record, starting with the prosecution?
Yes, Your Honor. Good afternoon. My name is James Keogh, P82812 on behalf of the people.
Good afternoon, Mr. Keogh.
And good afternoon, Your Honor. James Schloff on behalf of Mr. Tate. My bar number is 30720.
Good afternoon, Mr. Schloff, and good afternoon, Mr. Tate.
Good afternoon.
First things first, Mr. Tate, can you hear us clearly?
Yes, sir.
If at any point you cannot hear us, raise your hand and we'll try our best to resolve the technical issue. You understand?
Okay. Yes, sir.
We're here today for a status conference. By way of background, the parties are appearing by Zoom video conference, and that's pursuant to emergency orders entered by the Chief Justice of the Michigan Supreme Court and the Chief Judge of the Third Judicial Circuit. That's why we're appearing this way today. By way of further background, Mr. Tate has been charged in a one-count information alleging delivery or manufacture of controlled substance. Specifically, it's alleged that he delivered less than 50 grams of a mixture containing a detectable amount of cocaine. Let me start by turning to the people. Mr. Keogh, are the people in a position to place an offer on the record today?
Sorry, I was on mute. Yes, Your Honor, the people would offer the reduced count of possession of cocaine, heroin, or another narcotic less than 25 grams with a sentence agreement of 7411 if the defendant is eligible.
Well, Your Honor, that is a offer that I need to discuss with my client. But I'm not quite sure that we can take advantage of it today. I'm a new attorney on the case. I was in front of Judge Chalinsky and he appointed me to represent him. I have no discovery yet. And I certainly would like to have all the facts in front of me before we come to a decision like that. So I would like to address my client's bond in this matter, hopefully get a personal bond for him and get him out so I can talk to him.
Before we do that, Mr. Schloff, we're going to go ahead and set some other dates.
Very good.
Bear with me one second. Mr. Schloff, do you anticipate filing pretrial motions as it relates to this case? Probably
Again,
hard to say if you have.
It's hard to say.
Okay. Okay. Mr. Keogh, when do you think the people can have discovery to the defense, or at least make?
At the very latest, Your Honor, the end of next week. However, I'm confident it could be done within the next couple of days.
Thank you.
Okay, bear with me one second. We're going to set a motion cutoff of
I'm sorry.
September 11th.
I didn't hear you. Someone's talking over.
1 second, Mr. Schloff. Okay. We had a little bit of feedback there, so I'm going to start again. We're going to set a motion cutoff of September 11th, 2020. We're going to set a pretrial conference date and motion hearing date of September 25th, 2020. At that point in time, we'll hear any motions that have been filed, or we'll have a hearing on any motions that have been filed. We'll also have a pretrial conference. I want to explain at the front end how our process for trying cases looks somewhat different than it's looked in the past. This is probably not new information for Mr. Schloff or Mr. Keogh, but it will be new information for Mr. Tate. Previously in Frank Murphy Hall of Justice, each judge assigned to a trial docket was responsible for trying any of the cases on his or her docket. Going forward, or at least for the duration of the COVID-19 pandemic, there will be a separate trial rotation. So once a case is certified as trial ready, meaning that plea negotiations have been exhausted, there is one side or the other has insisted on a jury trial, and the motions in limine and other pretrial matters have already been decided. We'll send the case to court administration and it will be placed on trial rotation with a order of preference for the oldest in custody cases being tried first. I say all that to say, if either side elects for a jury trial in this case, and this case goes to trial, I may not be the judge trying Mr. Tate's case. I just want to make that clear on the front end. I've specifically set the September 25th date as a pretrial conference rather than a final conference, because going forward, the final conference will function as a plea cutoff, meaning no reduced pleas will be accepted after that point in time. So to reiterate, we'll have a motion cutoff of September 11th, 2020, and a pretrial conference and motion hearing date of September 25th, 2020. On that date, we'll set additional dates as necessary, including a date for witness lists, motions in limine, and a final conference date. Anything else aside from the issue of bond, starting with the prosecution?
No, Your Honor, nothing on behalf of the people. Thank you.
Mr.
Nothing
Schlott?
on behalf of the defense, no.
Okay. Am I correct in understanding there's a motion to reduce the bond amount?
There is, Your Honor.
Okay. Go ahead, Mr. Schlott.
Your Honor, I've had a chance to interview my client since I was first assigned to him by Judge Chalinsky. He's 21 years old. He's presently not in school. Until the time of the COVID, he was working at a some type of air conditioning heating factory, I believe. Not full-time, but he was working. He does have family that he's connected with and could return to. His mother calls me frequently about this case. And in fact, she contacted me today. I have no past criminal history for him, Judge. So he's 21 years old. Based on all that, based on a good offer, if he decides to take it, he has every incentive to return to court. I will be in touch with him. I'll teach him about Zoom. I would ask for a personal bond in this matter.
Okay.
But there's nothing up in there. There's he's on a 10,000. He's on a 10,000 personal bond for the GPS seller. That was pretty. Nothing in the.
Okay.
Action.
Before we turn to the prosecution, for a response, our records indicate that Mr. Tate already has a personal bond of $10,000 with a GPS tether. My assumption is that there's been some issue or delay in getting the tether attached, either a delay in getting him in the queue or a shortage of tethers. Again, that's an assumption. I'm not sure if that's the case. Mr. Kehoe, what's the people's position on this, including the people's position in modifying the bond to remove the tether requirement?
Yes, Your Honor. First, I guess for the most part, I agree with Mr. Schloth. There doesn't appear to be any criminal history here. I don't have a current lien, which is the only reason why I can't say for certain. That's why we're not sure about the 7411 just yet, but I'll know later today. And then as for the GPS tether, I'm guessing this is that same issue we've been seeing, that either they don't have enough tethers or whatever, and so they're holding Mr. Tate for that reason.
Well, Your Honor, there was a time when there was no such thing as a tether, and plenty of people did return to the court under those circumstances. So I would ask the court to consider removing any requirement of a tether.
Okay. Okay, I appreciate the arguments of both sides. I'm guided by Michigan Court Rule 6.106, which governs pretrial detention and release. I'm persuaded by the arguments of defense counsel. I will note that although there was a time before tethers, there are provisions within the court rules that allow for a third-party custodian. I think based on the representations of counsel today, this would be a case where the mother would probably, if she were present for this hearing, would probably be appropriate as or a viable candidate for a third-party custodian under 6.106 subsection D2J.
Mama, thank you. Set him on my bed.
The reality is we don't have her here today, and I want to make sure we address bond promptly. The two primary considerations, as both lawyers are aware, are the risk of non-appearance and the risk or the safety of the community. Here, based on the charge in this case, based on the people's offer, which appears to indicate that there may be limited, if any, prior criminal history. And frankly, the disincentive to commit other crimes while on pretrial release based on what appears to be a relatively sweet offer for 7411. In my view, there are terms and conditions that can reasonably assure Mr. Tate's appearance as required and the public safety. With that, and again, taking into consideration the COVID-19 pandemic and taking into consideration the fact that there may simply be a lag in the availability of tethers, I'm going to remove the GPS tether requirement. Yeah. We're going to remove the GPS tether requirement and leave the $10,000 personal bond in place. Mr. Schlaff, may I briefly address you?
Briefly address what, Judge? My client?
Yes, Mr. Schlaff, may I briefly address your client?
Please.
Mr. Tate, have you been able to follow along with us so far?
I'm sorry, I can't hear you.
Have you been able to follow along with us so far?
It's going in and out. I couldn't hear you. I'm sorry.
Let me summarize what happened so far. And if you can't hear me, simply raise your hand.
Yes, sir.
Okay. The lawyers and I have been talking about your bond amount. It appears that there's an issue. We requested that I remove the tether requirement altogether. You understand that?
I couldn't hear you.
Folks, 1 second. There appears to be a technical difficulty on our end. Here. Folks, bear with us 1 second. Tate, can you hear me now?
You're faint, Judge.
Mr. Tate, can you hear me now?
Yes, sir.
Sir, to recap what we've done so far, the lawyers and I have been discussing your bond amount, and your lawyer has requested that we move one of the requirements, the GPS tether. Do you understand that?
Yes, sir.
You understand that the requirements would be for you to show up to court as required, which may include showing up for a Zoom video conference and to remain crime-free while you're out on bond. Do you think you can do all that?
Yes, sir.
Okay. I'm gonna remove the GPS tether requirement and leave the personal bond of $10,000. Again, our next date will be September 25th, 2020. That will be at 1 p.m. and that'll be by Zoom. Yes.
Judge, is the September 25th date strictly for jailers? And will we need a new date based on that?
No, the September 25th date is our date for out of custody hearings.
Very good,
So
thank you.
1 p.m. on September 25th.
Thank you, Judge. Mr. Tate, call me when you get home. Your mom has my number.
Anything else on behalf of the prosecution?
No, Your Honor, thank you.
Anything else on behalf of the defense?
No, Judge, thank you.
With that, we're adjourned. Thank you. Ms. Soroki, are you still on the call?
Yes, Your Honor. Sorry.
It's my understanding that you may be our House counsel for today.
I am, Your Honor. Good afternoon.
Good afternoon. we've got an extradition that's currently waiting. I'm gonna put you in a breakout room with Mr. Ryan Anderson to allow
Thank
you
you.
to speak with your client.
Thank
Mr.
you.
Anderson, can you still hear us? Mr. Anderson, can you hear us?
Yes, sir.
Okay, we're gonna put you in a breakout room with your lawyer. One moment. They have a Langford Division 3. Yeah. I don't have him on this list. Huh? Langford? Langford is showing on our docket. Okay. Docket, the regular court docket, Langford, that they put on. Got two cases, got two hearings. And he set it on our docket. Yeah, the rain by Cusick. They did a bond motion, like Cusick did. Tracy Green. Both of them are probation violations? Yeah, they are, yeah. Okay. And he's been arraigned on both matters. They just set him somewhere else and they set him on our docket. Okay. Yeah, Judge Green arraigned him on July 30th. Gave him a personal bond with a teller. Then he went before Judge Cusick on the 19th on a motion to reduce bond. He denied it. Okay. Agent Smith, are you here on Mr. Langford's case?
Yes, Your Honor.
Okay. Mr. Langford.
And Jones also.
I'm sorry?
And Jones also.
Okay. Mr. Langford, can you hear us clearly?
Yes, Your Honor.
Okay, one moment. Melissa Kleiman. Yeah. Oh, that's when it's used. I guess Judge Cusick appointed her on that, on the emergency bond motion day. Yeah. Okay, that's gonna be Mr. Rookie. Mr. Langford, we're gonna put you in a breakout room with your lawyer in one moment. Bear with us 1 second.
Thank you, Your Honor.
Mr. Roki, are you all set on Mr. Anderson?
I am, Your Honor. Thank you.
Okay. Mr. Anderson, can you hear us?
Yes, sir.
Okay. You can do the extradition next. I'll ask them.
Okay. This is off the docket of the Honorable Deborah Thomas. This is case number 20-3039, People State of Michigan versus Ryan Joshua Anderson, here for extradition matter.
Can I get the appearances for the record, please, starting first with representatives of the Wayne County Sheriff's Office?
Corporal Penzen with the Wayne County Sheriff's Department Extradition Unit.
Good afternoon. Ms. Soroki, your appearance?
Your Honor, good afternoon. Pauline Soroki on behalf of Ryan Anderson.
Good afternoon, Ms. Soroki, and good afternoon, Mr. Anderson.
Good afternoon, sir.
First things first, Mr. Anderson, can you hear us clearly?
Yes.
If at any point you cannot hear us, simply raise your hand and we'll try our best to resolve the technical issue. Do you understand?
Yes, sir.
We're here today for an arraignment on an extradition matter. By way of background, there's an extradition warrant specifically from Sarasota County, Florida, alleging a failure to appear on a case related to fraudulent use of personal identification information. Mr. Anderson, let me inform you, a demand has been made for your return to Sarasota County, Florida, where you appear to be charged with failure to appear in a criminal case involving allegations of fraudulent use of personal identification information. I want to inform you of some rights. Sir, you understand you have a right to challenge this warrant of extradition and to test the legality of these proceedings. Do you understand that?
Yes, sir.
Sir, you understand that we have appointed counsel for you today. That's Ms. Soroki, who you were just in a breakout room with, but you also have a right to retain counsel if you so choose. Do you understand that?
Yes, sir.
Sir, do you intend to seek a hearing regarding the validity of this extradition warrant, or do you intend to waive your right to challenge the extradition warrant and acknowledge and agree to the extradition?
I agree to the extradition.
So you understand that means that Sarasota County, Florida will come to pick you up to have you transported back to Florida to address the remainder of your case in Sarasota County. You understand all that?
Yes, sir.
Okay. Ms. Soroki, do you want me to make any further inquiries of your client?
No, Your Honor, I'm satisfied that he understands the extradition process.
Okay. We're going to set a review date of September 3rd, 2020. That'll be a 2-week review date. Sarasota County has until then to pick up Mr. Anderson, though we expect that it'll be well in advance of that date. Let me turn to the Sheriff's Office. Corporal Penton, do you all have an executed waiver from Mr. Anderson?
Yes, we do. And I had emailed it to Darren.
Okay. Go ahead and execute the waiver on our end. Anything else on behalf of the Sheriff's Office?
No, Your Honor, thank you.
On behalf of the defense, Ms. Soroki?
No, Your Honor, thank you.
With that, we're adjourned. Thank you.
Thank you. Good luck, Mr. Anderson.
Ms. Soroki, we also have Mr. Langford here on an alleged probation violation. Let me give you the case number. It's case 19-50-01-FH.
Judge, I believe there's 2 cases for Mr. Langford.
Yes.
That's right. We're looking up the other case number. Thank you for that. I'm sorry, it's Mr. Langford in Division 3, correct?
It's 19, 16, 68, and 19, 530. 16, 68, 19, 16, 68, and 19, 530.
Ms. Soroki, it's my understanding Mr. Langford has already been arraigned on his violation warrants. We're gonna email you copies of those for today's purposes. And then
Thank
we'll
you.
put you in a breakout room with it.
Thank you. My email is sarokilaw@gmail.com.
Thank you, Ms. Soroki.
Do we have probation?
Yes.
Can I go in a breakout room with her also, Your Honor, first, maybe?
Absolutely.
Thank
One
you.
moment.
Your Honor, this is Agent Graham from MDOC. Can you also put me in that breakout room just in case Ms. Soroki has questions for me?
Absolutely, Agent Graham.
Thank you.
Ms. Karen Dongo, do you need more time with your client?
I spoke to him in the breakout room, Your Honor.
Okay.
And I'm not sure because I see his facility on here, but it looks like a different room than what it was before. And so I'm not really sure if it's just that the camera is turned a different way or, oh, okay, got it. All right, there.
Okay.
Okay, he's there. It's the same room.
It ain't facing me right now.
Mr. Haywood, can you hear us clearly?
Yes, sir. The camera not facing me right now, though. It's turned to the side.
Right.
Okay, one moment. Mr. Haywood, if you can, get the attention of a corrections officer nearby to assist you with the
Okay.
video.
Okay, hold on.
Division 1, 6th floor. Do you have anyone else for us today?
Yes, Your Honor. I have, actually, I have 6 people for you. I have Ash,
Okay,
Anderson,
okay.
Hyde, and I got Norbert Jones,
Okay.
Adam Dickey, and then I have one more person. It's D'Angelo Martin. He's down on the floor still, but I was gonna grab him whenever you're ready for him.
Deputy D'Angelo Martin has been moved to August 25th in front of Judge Thomas.
Okay.
Gina.
Okay. August. Okay, I have him. And then, who would you like to see first? I can have him sit in front of the camera for you.
If it's possible to do Ash or Anderson first.
Okay.
The same defense attorney on both cases.
Okay, I'll bring Mr. Ashton.
Mr. Kinney, will you need to go in a breakout room with Mr. Ash and or Mr. Anderson?
Not unless they want to talk to me, no.
Okay.
When he comes out, we're gonna go in, all right?
Counsel on Mr. Haywood's case, we're gonna take care of 2 matters and then we'll take care of Mr. Haywood's case.
Okay, Your Honor.
Thank you.
Sounds good.
Mr. Ash, can you hear us clearly?
Yeah.
Okay.
Okay. This is case number 19-2264 and 19-2343. People State of Michigan versus Brian Ash.
Can the parties identify themselves for the record, starting with the prosecution?
Yes, good afternoon, Your Honor. Carly Cox on behalf of the people, P81911.
Good afternoon.
Good afternoon, Your Honor. Robert Kinney appearing on behalf of Mr. Ash, 35842.
Good afternoon, Mr. Kinney, and good afternoon, Mr. Ash.
Good afternoon.
First things first, Mr. Ash, you can hear us clearly?
Yes.
If at any point you cannot hear us, simply raise your hand and we'll try our best to resolve the technical issue. Do you understand?
Yes.
Okay. We're here today for a continuation of a final conference. By way of background, last time we were here, there was a reduction in the bond amount. I believe the people also placed a new offer on the record last time we were here. As it stands right now, my hope for today is to give the attorneys a hearing date for the pending motion to sever, motion to consolidate, and that hearing date function as the final conference where we will take care of any remaining trial readiness issues, also function as a plea cutoff. Let me start by turning to the prosecution. Ms. Cox, for good measure, can you reiterate the people's most recent offer?
Your Honor, let me grab that real quickly. It's obviously, as the court knows, the file is quite thick. I only have a bifurcated portion of it right now. So if the court would just hang on one moment, please.
Take your time.
Your Honor, the current offer would be for Mr. Ash to plead to one count of human trafficking of a minor and one count of prostitution, transporting person. All other charges against him would be dismissed. There would be a sentence agreement. It would be 8 to 20 years with the Michigan Department of Corrections. And the trafficking of a minor also includes a SORA compliance, which is a tier 2.
Thank you. Mr. Kinney, has that most recent offer been communicated to you and your client?
Yes, that's the same offer, but
One second, Mr. Kinney, because we're getting some feedback. Mr. Kinney, I was asking, has that offer been communicated to you and your client?
yes.
Okay.
Your Honor, I would note for the record that at the last hearing date, Mr. Kinney and I did have a conversation in a breakout room. As the new prosecutor on the case, I told him that I would take any other offer that he suggested to my supervisor to see if it could be lowered in any way. It's my understanding right now that it won't be, but I will have that discussion with my supervisor.
Okay, fair enough. Okay, so as it stands right now, we still have the motion to sever, and that relates to co-defendant Grace Nirabi Mana, and that's spelled N-Y-I-R. One second.
You want me to spell it for the record, Your Honor?
I've got it right here, Mr. Kinney. Sorry for the.
No problem.
That's spelled N-Y-R-A-H-A-B-I-M-A-N-A. There's a motion to sever Nirabi Mana from the information and a motion to consolidate Mr. Ash's 2 cases for trial. Mr. Kinney, for good measure, does the defense intend to contest either or both of those motions?
Your Honor, I've had an opportunity to look at both of them, and I think I would rely on the court without argument on both cases. I had an opportunity to talk to the prosecution, and with respect to the motion to sever, they didn't put any evidentiary issues in the motion, and it was Mr. Champagne that indicated that there were, he wasn't arguing any evidentiary hearings, he just wanted to separate them. And I don't have any objections to that.
Okay. Okay, then let's set some other dates. And I can issue a short order. If I'm hearing you correctly, Mr. Kinney, there's not an objection to the severance, but there may be an objection to the consolidation?
Yes, Your Honor.
Okay. Folks, give me 1 second. I'll get you some other dates. Council, we're gonna set a hearing date on the motion to consolidate and motion to sever on September 15th at 1 p.m. That'll be on the D docket on the court's COVID schedule. I also want to provide some other dates. We're going to require the parties to file any amended witness lists or new witness lists no later than September 1st, and any motions in limine due on September 8th. September 15th will function as a hearing date for any motions in limine that have been filed, and on the motion to sever and motion to consolidate. The September 15th date will also function as a final pretrial conference and plea cutoff, which means after that date, no reduced pleas will be accepted. Starting with the prosecution, does that date work for the people?
Yes, Your Honor.
And Mr. Kinney, does that date work for the defense?
Yes, sir.
Counsel, I want to bring to your attention, the court has a trial readiness checklist, and my hope is that on that September 15th date, we can complete that checklist. Ms. Cox, to your knowledge, are there any lab reports or expert reports that have yet to be turned over to the defense?
No, Your Honor.
And at risk of asking an obvious question, folks, am I correct in understanding this is going to be a jury trial?
Yes.
Okay. Ms. Cox and Mr. Kinney, prior to that September 15th date, around September 8th, I'll circulate a copy of the preliminary jury instructions and the proposed final jury instructions. If there are additional special instructions that you want included, please circulate those on that September 8th date. And if there's any issue with the jury instructions, we can hammer those out on September 15th. I'm required to include those in the package that goes to court administration to get Mr. Ash in the queue for trial. So again, I'll circulate the court's jury instructions, which will include the pattern jury instructions that apply to this case. And if you've got issues with those or want additional instructions included, simply come prepared to discuss those on September 15th. Ms. Cox, will the people's offer be good until September 15th?
Yes, Your Honor.
Okay. Anything else today on behalf of the prosecution?
No, Your Honor.
Mr. Kinney, anything else on behalf of the defense?
I just want to reiterate, I'm hoping for a better offer. That's it.
If I heard the prosecution correctly, it sounds like they're open to continuing that conversation. So I'll leave that to the parties. And if you all need a hearing in advance of the September 15th date, just simply contact each other, contact the court, and we can get you on the docket.
Your Honor, I know I had a bond motion. I know I filed one and all. And I know you know a lot about this case, but I just want to remind you that the co-defendant, and may he rest in peace, but he had a more extensive record, and he also had more serious involvement in this case than Mr. Ash. And he received a personal bond in this case. I know he had COVID-19 and all at the time, but I believe he had a personal bond.
Mr. Kinney, that's not accurate. I believe Mr. Ash and Mr. Brown's bond were both set at $75,000 cash surety bond, and Mr. Brown ended up posting that bond. We've since reduced Mr. Ash's bond from that amount. Let me confirm that. just so the record is clear, the bond was lowered for both defendants previously in this case, and I believe around July 3rd of 2019, prior co-defendant Eric Brown posted on a $150,000 cash surety bond with a GPS tether. But Mr. Kinney, just so I'm clear, you're asking the court to revisit bond?
Yes, sir.
Okay. This is something that's been on my radar for a while. This case is one of the older cases on my docket, and I've previously lowered bond at least twice as it relates to Mr. Ash. In good conscience, I can't lower it beyond what it's already been lowered to. And I've closely looked at the requirements of the Michigan Court Rule 6.106, and there's no way in good faith I can lower his bond based on the charges present, the already low bond that's been set, that's been reset based on his financial condition, and taking into account third-party custodians that we previously had in court. There's simply no way I can lower it beyond what it's been lowered to. I think we've hit a floor in this case. So I'm denying the request. Anything else on behalf of the defense, Mr. Kinney?
No, sir. Thank you.
Okay. With that, we're adjourned.
Thank you, Your Honor.
It's down to 50, down to 50.
Okay.
GPS tether, 50,000. GPS tether, house arrest, no contact with minors, no contact with complainants and or witnesses in this case. That was done July 21st. 50,000.
Ms. Soroki, are you ready on Mr. Langford's case?
An incident,
Sorry, I had you on mute
sorry.
for a moment.
I'm sorry. I haven't received the warrants yet, and the probation is waiting for a new warrant that happened over the weekend.
Okay, bear with us 1 second. We'll send you the warrants.
Thank you.
Get Jason to send that to her. Give me 1 second. And then it looks like we may have lost Division 1. But they said they've got 5 other people for us.
Ash was in Division 1.
Division 1. Yeah.
I still
Mr.
have.
Ash, Mr. Ash, you can inform the deputies that we're done with your case. Wayne County Division 1, 6th floor. Who do we have? Can you please identify yourself?
Demondo Anderson.
Good afternoon, Mr. Anderson.
Good afternoon.
Smith, ready on Mr. Anderson's case?
Yes, Your Honor.
And Mr. Keough, you're the prosecutor on that case?
That's correct, Your Honor.
Okay.
That's right. This is case number 194976. People State of Michigan versus Demando Anderson. That matter is here for sentencing. He also has case number 183177, and that matter is scheduled for a violation hearing. Just tracking the other case.
Can the parties identify themselves for the record, starting with the prosecution and the probation department?
Yes, Your Honor, good afternoon. My name is James Keough, P82812 on behalf of the people.
Good afternoon.
Good afternoon, Your Honor. Andrea Smith on behalf of the probation department.
Good afternoon, Agent Smith.
Good afternoon, Your Honor. Robert Kenny appearing on behalf of Mr. Anderson.
Good afternoon, Mr. Kinney, and good afternoon, Mr. Anderson. Just 1 second as we unmute Mr. Anderson's microphone. Sometimes I can unmute, sometimes I can't. Mr. Anderson, can you hear us clearly?
Yes, sir.
If at any point you cannot hear us, simply raise your hand and we'll try our best to resolve the technical issue. Do you understand?
Yes, sir.
We're here today for essentially a status conference. It was listed in the docket as a sentencing hearing, but we're required to, because of the lag between the guilty plea and the sentencing date and the subsequent delays due to COVID-19, we need to re-refer Mr. Anderson for the preparation of a pre-sentence report. Agent Smith, it's my understanding that re-referral is already in process. When does the probation department expect that the pre-sentence report can be available?
August the 27th, Your Honor. The defendant was interviewed today for the PSI.
Okay, fair enough. Okay. Folks, with that in mind, my intention is to set sentencing for August 31st. That is our next in custody date. Let me start. 1 second. Yeah. Mr. Kinney, how does August 31st at 9 a.m. work for the defense?
I got several, well, they're district court cases, but I've got 3 of them. And one of them is a preliminary exam.
Okay. Sounds like that date may not work. Bear with us 1 second. September 15th. The next one after August 31st. The next in custody date that we have after August 31st is September 15th. Mr. Kinney, starting with you, I think you'll be here for Mr. Ash's case, the September 15th.
Yes, sir, I will. That's a good day.
Okay, September 15th at 1 p.m.
Yes, sir.
Mr. Keough, does that work for the prosecution?
That works for the people, Your Honor.
Smith, does that work for the defense, or excuse me, for the probation department?
Yes, Your Honor.
Okay. We'll set sentencing in this matter on September 15th at 1 p.m. And that'll be on the D docket on the court's COVID schedule.
Yes, sir.
anything else today on behalf of the probation department?
No, Your Honor.
And Mr. Keough, anything else on behalf of the prosecution?
No, Your Honor, thank you.
Mr. Kinney, anything else on behalf of the defense?
Well, Your Honor, I know that Mr. Anderson wants me to make a motion for bond at this particular time. I understand that it's a remand now. We had a hearing about the tether violation. And I understand that a lot of the violations were late at night, early in the morning, but he continues to tell me that he was picking up his daughter who was ill and severely ill, trying to help his child's mother. That's the reasons for him being out. He always went back home.
And not to shortchange the prosecution, Mr. Keough, what's the people's response to the request for bond modification? The request to reinstate bond, I guess.
Your Honor, the people would oppose, and as we stated at the last hearing, these tether violations all occurred early in the morning, and all of them, as even the court had indicated, were not at a hospital, and some of them were even at addresses that came up for liquor stores. So we would oppose any reduction at this time.
Okay. Folks, just to be completely clear, I reviewed the tether violation report from the Wayne County Sheriff's Office. Prosecution is correct that at least one of the incidents, and there were several incidents, one of them was at a liquor store around 10 o'clock or 11 o'clock at night. Prior to Mr. Anderson's hearing in front of Judge Green, I contacted Judge Green to let her know the background of this case and why there was such an extensive gap between the guilty plea and the sentencing hearing. The first was to allow Mr. Anderson to help with his child, and the second was to allow Mr. Anderson, I believe, to complete some schoolwork. The long and short of it is Mr. Anderson squandered that opportunity and he will remain on remand status. Mr. Kinney, anything else on behalf of the defense?
No, sir. I see he has his hand raised, but I would suggest to him not anything. There's a sentence agreement in this particular case. I wouldn't want him to say anything that might hurt the plea that we already had.
Okay, and Mr. Kinney, I'm gonna turn to him in a second, but unless it's a question, we're gonna save it for the sentencing hearing and he'll have an opportunity to speak at allocution. 1 second, Mr. Anderson.
Thank you for that.
Folks, 1 second as I try to unmute the microphone. Mr. Anderson, have you been able to follow along with us so far today?
Can you repeat that?
Have you been able to understand what's happened here today?
Yes, sir.
Okay, you raised your hand. Is that because you could not hear us?
No, I had a question.
What's your question, Mr. Anderson?
Okay, now the thing, I'm in school and I had 20 classes and I completed 18 classes. I have 2 more before I get my diploma.
Let me stop you right there. If you have a question, ask your question.
Can I get to complete my classes? I just wanted to complete my classes. I have 2 more classes left and now I have my diploma.
The short
I'm
answer
so
is
close.
no. Mr. Anderson, the short answer is no. The longer answer is not right now. You'll remain in custody until your sentencing hearing on September 15th. That, nothing further from the defense or the prosecution. We're adjourned. Thank you.
Why so far? Why the sentence today so far?
We're adjourned. Thank you.
Thank you.
Ms. Kirandango Bonsu,
Yes, Your Honor.
Ms. Dawson. Are you all still able to hear us?
Yes, Your Honor.
Yes, Your Honor.
Okay. Thank you for your patience. We'll call Mr. Haywood's case next. Still hear us?
Good afternoon, Your Honor. Lori Dawson, on behalf of the people.
Dawson, we haven't called the case yet. We'll call it in a second.
Okay, thank you.
Thank you.
Okay. Ready?
1 second. I'll just check to make sure. Ms. Soroki, are you still on the line? Ms. Soroki, are you still on the call?
I am, Your Honor.
Have you received the documents from the court yet?
No, but I just talked to your staff and he's going to send them right now. Probation's waiting for a third warrant. I don't think they have it yet.
Your Honor, I just received another email from Ms. Gasson, who is the supervising agent for Mr. Lanford. She's informed me that she will not be able to get me that warrant today. It has to be cleared. She will have it by tomorrow.
Okay. And this is a warrant, just so I understand, this is a warrant that's already been approved, or this is a warrant request?
No, Your Honor, it's going to be a warrant request regarding the arrest of this weekend for Mr. Langford.
Okay. Okay. So Ms. Soroki, once you get the documents, we can put you in a breakout room. Simply send a chat to the court and we'll try our best to put you in a breakout room as soon as we can.
Well, I'm wondering okay, I'll talk to him, but with the new warrant coming, I mean, I'll go ahead and talk to him though. No problem. I do have the warrants. He sent them right now, so you can put me in.
Okay.
Oh, no. Oh, yeah, I do have them. Thank you.
Okay, one moment.
Thank you.
Okay. All right, so we're ready on Haywood.
Ready on who?
Haywood.
Oh, okay. Come on. Motion. Okay. This is case number 97-500-792. People State of Michigan versus Lionel Haywood. Here for a motion.
Can the parties identify themselves for the record, starting with the prosecutor's office?
Morning, Your Honor. Good afternoon, Your Honor. This is Stephen Carr on behalf of the people, P83623. And here with me is Lori Dawson.
Good afternoon, Your Honor. Lori Dawson, also on behalf of the people, P number 40665.
And good afternoon, Your Honor. Cecilia Kirandango, P68374, on behalf and with Mr. Haywood. We're participating by Zoom video with no objection.
Good afternoon, Mr. Haywood.
Good afternoon, Your Honor.
First things first, Mr. Haywood, can you hear us clearly?
Yes, sir.
If at any point you can no longer hear us, simply raise and wave your hand and we'll try our best to resolve the technical issue. Do you understand?
Yes, sir.
Okay. We're here today on the defense's emergency bond motion pending a Miller resentencing hearing. That's a reference to Miller versus Alabama, 567 U.S. 460, 2012 case related to resentencing hearings for individuals that were sentenced to life without mandatory life without the possibility of parole while juveniles. That motion was filed on August 10th, 2020. The people filed a response in opposition on August 12th, 2020. And I'll note by way of background, this is a case where the people had filed a motion pursuant to statute seeking to reimpose a sentence of life without possibility of parole. That matter has been pending, and as I understand it, or at least as is represented in defense's motion, part of the delay in this case is the COVID-19 pandemic has created some delays. We'll hear first from the defense and then from the prosecution, and then because it's the defense's motion, defense will get the last word. Ms. Kirandangu, the floor is yours.
Thank you, Your Honor. In regards to this motion, we filed this motion for a couple of reasons. Mr. Haywood's sentence was vacated a number of years ago now. He has been awaiting resentencing for in excess of 4 years. I have asked that his case move forward since the time that I was appointed, which is some years ago. I was not Mr. Haywood's first attorney that he had for purposes of resentencing, but been told that because he hasn't served this many years that he's way down the list to be resentenced. So we don't have any dates in this case for Mr. Haywood. I will tell the court that, you know, we're ready to proceed whenever the court is ready to proceed. We have some reports that have been done for him. We need updates on those, but you know, when we get dates set, we're ready to go. In addition to that, of course, we've been going through COVID-19 now for several months. It creates within the Michigan Department of Corrections, it had created a state where there's no possibility of social distancing. The inmates are at heightened risk because of this. Mr. Haywood has indicated to me that he is with 16 other people with no possibility of social distancing. He also suffers from high blood pressure at increased risk of should he contract COVID-19. As the court may be aware, should be aware, the numbers in Michigan were going down, then we're going back up, and we're still having new cases in the hundreds every day. Mr. Haywood has served over 24 years of a sentence. He was offered a plea bargain back in the days, which he pled to, and then subsequently withdrew his plea, where he would have looked at a minimum sentence of 15 years. In this particular case, if the court was to impose, let's say, a term of years that was towards the bottom of the range that's given, he would be eligible immediately for parole. Mr. Haywood wanted the court to know that during his, I don't want to say trial, but during the pendency of his case, the trial attorney had and that, so I'm just going to give the court the date if the court wanted to go read the transcripts. But on April 28th of 1998, the judge had in the transcript, 5-page long conversation with Mr. Haywood, you know, about wanting him to take the plea offer that had been given to him. Because the judge didn't feel that he should be serving a sentence of life without parole. You know, I've cited the due process. I've cited the fact that he's sat now for over 4 years on a vacated sentence, and the fact that he has no prospect really of being resentenced anytime soon for the reasons in this motion. I think the court can use the 8th Amendment, and also the fact that we are, you know, supposed to be having these Miller hearings in a timely fashion as a reason to give Mr. Haywood a bond.
Ms. Kirandangu, a few questions. One, when
yes, Your Honor.
Your argument that if he's sentenced to a term of years, he would be eligible for parole immediately, doesn't that require, as I understand it, some calculations on the part of MDOC to determine his good time credit as it affects his sentence? And his
yes, Your Honor. Mr. Haywood qualifies for the good time credit because he's been incarcerated. That law was passed after he became incarcerated. So with his 24 years that he has served, which is real time, if he was given a 25-year sentence, he would be immediately eligible because he would have served with his good time credit in excess of the mandatory minimum. Now, of course, there's a range. So if the court was to impose a term of years and the court imposed 40, that's different. But if the court was to impose a sentence towards the lower end of his range with his good time credit, he would be eligible immediately to be seen by the parole board.
Okay. 1 second. Ndongo, you indicated this is somewhat tangential to the present motion, but you indicated that the defense in this case would be ready to hold a sentencing hearing or the Miller hearing and resentencing hearing kind of at the court's earliest available date. While we have you here, does that mean that you and Mr. Haywood would be willing to conduct all or part of these proceedings by video conference?
So, Your Honor, Mr. Haywood and I just discussed that actually in the breakout room. I've conducted hearings on Zoom with witnesses and experts. Part of the difficulty right now is that the MDOC is candidly not allowing us to go into the prison, so I wouldn't be able to sit with him. Mr. Haywood actually said that we could conduct it on Zoom. There would be a number of experts. If Mr. Haywood felt comfortable with it, I'm comfortable with it. It's not something we would typically do. Typically we would have these hearings in person, and Mr. Haywood would be brought to Wayne County, which can't happen right now either. I'd be able to, after half a day or whatever, I could go see him, talk to him if there were things that we needed to talk about. And of course, Zoom, makes that difficult. Now, Mr. Haywood was actually the one that told me, he says, we can have the Miller hearing on Zoom. Like I told the court, I know how to share documents on there. I've conducted some evidentiary hearings on Zoom. It wouldn't be my preference.
Okay, fair enough.
But if the people they're gonna turn around and say, well, look, she doesn't want to have a hearing by Zoom, so he's gonna be sitting anyways, and it's gonna be delayed because of that. I know I could do it by Zoom if that makes sense. It would just be up to Mr. Haywood.
Okay, fair enough. Anything else, Ms. Kirandongo, as it relates to the emergency bond motion?
No, Your Honor.
Let me turn to the people. Mr. Carr or Ms. Dawson, who's going to be arguing on behalf of the people?
I'll be doing the argument.
Go ahead.
Thank you, Your Honor. So a couple of points. First of all, as we brought up in our motion, there's no clear, this is a situation where Mr. Haywood has been convicted. His conviction has been affirmed on appeal. This is not a situation where he's seeking bond pending appeal. Even if that were, the fact that he's been convicted of an assaultive crime means that he needs to show by clear and convincing evidence, first, that there's a substantial issue for appeal and that he's not a threat to the community. And I think he fails on both of those. He doesn't have a substantial issue for appeal because we can see that he needs to be resentenced. There's a statute that permits him to be resentenced under that statute. To have an issue for appeal, there would need to be some problem with that sentencing. And that would presume some sort of error in the resentencing. And there's just no reason to presume that there would be an error and that would be a substantial issue. As to the threat to the community, I think his conviction alone for first-degree murder shows significant threat to the community. Also, he was convicted of another crime, assault with intent to commit murder just before that. Shot someone 6 times. And since being in prison, while Mr. Haywood points out that he doesn't have the worst record of any prisoner that we see here, he has several other misconducts, including an assaultive crime in 2006, where he attacked another where the hearing officer found that he attacked another inmate in the dining hall. And the hearing officer found that that inmate was believed by Mr. Haywood to have harmed his cousin, murdered his cousin. And so that conviction concerns us because it shows that he's willing to hold a grudge, to seek retaliation. So even if he doesn't have a number of assaultive convictions, it shows that there's still some risk to the community there. Also, he has a 2016 misconduct for smuggling drugs. And just finally, his earlier convictions, the assault with intent to murder and this first-degree murder conviction, were all done while he was on probation, showing that he's at a risk even if he's under supervision. Turning to the specific COVID issues that were raised, Mr. Haywood is at the Chippewa Correctional Facility, according to his motion. And I just looked it up this morning. There have been no prisoner cases at that facility. That's up in Chippewa County in the UP. There was one staff case. Also, Mr. Haywood is a 40-year-old man. This for the first time today, he represented he has high blood pressure, but other than that, I don't see him as a high-risk individual. We also talked in our motion about the steps that the MDOC has taken to provide protective equipment, to clean their facilities, to do social distancing. They've ended visitors. So there's a number of steps that the prison has taken. We don't mean to minimize the fact that there is real risk of outbreaks in prisons. But as I said before, the Chippewa Correctional Facility specifically does not appear to be a hotspot or a place where there's transmission. And a couple other issues that specifically were brought up in the argument. As Your Honor was sort of alluding to in your questioning, the minimum sentence for Mr. Haywood would be 25 years. So even if we presume he would get that minimum sentence, he would still need to qualify for some amount of good time credit to even be eligible for parole. Then once he's eligible for parole, he has to actually be granted parole. And we think that that requires too much speculation. Sorry.
Just to be clear, Mr. Carr, am I correct that to even get to that point, there's two assumptions. First, that the court decides after the Miller hearing that he should be sentenced to a term of years. And second, that the court were to sentence him to the lowest possible term of years.
Correct. The court would have to deny our motion for life without possibility of parole, and then second would have to impose a sentence that would be at the minimum before you would even get to that process of determining his good time credits and then his eligibility for parole.
Let me ask you this. Can everyone still hear us?
Yes, Judge.
Yes, sir.
Yes, Your Honor.
Technical issue, our Polycom just shut down on us. So Mr. Carr, I was going to ask you, along the same lines that I asked the defense, would the people be in a position to proceed via Zoom video conference for the Miller hearing, assuming Mr. Haywood waives his right to have the hearing in person?
Yeah, we've done a couple of Miller hearings over Zoom, and assuming that the defendant is willing to waive, of course, we haven't had problems doing that. We can bring in our victims via Zoom, and the experts can testify via Zoom, and it's not usually an issue.
Okay. Last question that I have for you regarding the first prong of the analysis for a bond pending appeal. Typically, it's bond pending appeal. For the substantial issue prong, what do you make of the response to your argument that there absolutely was an issue, a substantial issue or substantial error in his original sentencing, and that's illustrated by Miller and Montgomery, showing that, yeah, there's absolutely an issue when someone's been sentenced to mandatory life without parole as a juvenile. So that prong is immediately satisfied. What's your response to that?
Well, conceitedly, there is a an issue with that sentence, if he were to just, if there weren't any statute and he were to simply say, file a habeas motion, he would be entitled to a resentencing. But I think the issue kind of implicit in that substantial issue for appeal is the idea that there's a chance that he would be entitled to a reversal of his conviction. And that's not the case. We're still going to have a valid conviction in place. We're just going to need to change that sentence. And I would say that the statute is the remedy for that sentence. So in effect, he's sort of already prevailed on appeal, so to speak. You know, it's a strange analogy, but there is a mechanism in place for him to be resentenced in a way that would comply with Miller. And now we're just talking about scheduling all that. You know, we all agree on the issues. There's no real dispute about any of that. It's just, you know, admittedly, the logistics are difficult for a variety of reasons and for all the COVID stuff.
Okay. Anything else, Mr. Carr?
No, thank you, Your Honor.
Ms. Kirandongo, it's your motion, so you get the last word. Any responses to the prosecution's arguments or anything else to add?
Yes, Your Honor. So in regards to the, you know, the substantial issue argument, you know, I disagree with the people that there's no substantial issue. That he's going to be resentenced, and if the court was to give him a term of years, and I don't think it has to be at the bottom, but towards the bottom, Mr. Haywood would be immediately eligible for parole. So if he was granted parole, he'd be released. And I think the court can take that into consideration when the court is going to decide if it's going to continue to have Mr. Haywood be incarcerated pending resentencing. In regards to the risk to the community, Mr. Haywood was a young teenager when when the incidents that he's finding himself in prison for occurred. He has had no tickets at all since 2006. So the press is correct that there was a ticket, which is not a new conviction. He was not charged with a new crime for that back in 2006, which is 16 years ago. So it's well, 14 years, sorry. It's been a very long time. The other misconducts that he has, and that would be one of the experts that we would present to the court, are not something that's unexpected for someone who finds themselves incarcerated at a young age. I actually think it's pretty impressive at his age that he has had no assaultive tickets since 2006. So in regards to being a threat to the community, I just wanted to know too that he has multiple family members. Mr. Haywood has very strong family support. His mom is here. I saw some other family members before too on a different screen. They're up, yeah, they're waving at the court too. He has a lot of community support. He has a place to go. He has participated in some programming in the prison, not a whole lot. He's gotten his GED. He's made a lot of strides in the last 24 years in prison. So to just say that based on his conviction, he's automatically a threat to the community some 24 plus years later, I don't think that that's necessarily a valid argument. So, and with that, I think those were the things I wanted to bring to the court's attention, Your Honor.
Okay. I appreciate the arguments and briefing on both sides of this. I'm going to take the matter under advisement for today. You all can look for an opinion and order from me no later than Friday by close of business. But I also, in anticipation of kind of the next steps for Mr. Haywood's Miller hearing and resentencing, I want to set another date as a scheduling conference to make sure that this case doesn't get lost in the shuffle. Folks, 1 second. No, that's for scheduling
Mom,
conference.
Granny, I love you.
So, starting with the prosecution, the date I'm looking at for a scheduling conference, and again, I'll address the bond motion, a written opinion. It should issue Friday by close of business, Monday morning at the latest. But to make sure that we're setting new dates for the Miller hearing, if Mr. Haywood intends to have it by Zoom, starting with the prosecution, how does September 11th at 1 p.m. look for the people?
Your Honor.
Go ahead, Lori.
I'm sorry, Your Honor. A scheduling conference on Friday, September 11th at 1 p.m. is fine for the people.
Okay, fair enough. Ms. Karen Dongu, how does that work for the defense?
That's fine, Your Honor.
Okay, and we will coordinate with MDOC to make sure that Mr. Haywood is written for that hearing and can participate by Zoom. I acknowledge that Mr. Haywood appears to have some supporters present on the Zoom call. As a reminder to interested members of the public, the hearings are also broadcast on YouTube. So depending on your devices, you can participate in that way. I'll take the matter under advisement. You all can look for an opinion from me, ideally tomorrow before the end of the day.
Thank you, Judge. May I just say one thing to my client?
Go ahead.
Before I
Just a
disconnect,
reminder.
Mr. Haywood. Oh, I'm gonna follow up with you on the phone, okay, next week, Mr. Haywood, okay?
Okay, thank you.
All right, thank you, Your Honor.
Anything else? Anything for the defense?
No, Your Honor.
Anything else for the prosecution?
No, Your Honor, thank you.
No, Your
Okay.
Honor, thank you.
With that, we're adjourned. Thank you. Ms. Soroki, we can put you in a room with your client.
We're ready, Your Honor.
Ready? Okay, good.
Yeah, I've
deal.
already talked to my client. Probation's ready, so.
Okay. And that's the day we go out. Yeah, but we can do mostly those days too. Okay, that's Haywood. Okay, all right. What happened to it cut off midway through the hearing. See if I can reconnect us, but the sound is working through the laptop, so we'll stay on that for now. What was the prosecutor besides Ms. Dawson? Carr. I don't have the first name, but APA Carr.
You are in
Okay, so we're ready.
Your Honor, Mark Lake, and on my matter, is it possible to call the case soon? Only because I'm having a low battery problem here, and I'm worried that I'm going to lose my picture at about 8%.
That's fine. Give us 1 second.
Thank you.
Maybe we'll do Boykins first, then, and then Langford after that. Boykins, Gregory Boykins. I did not have it on. Yeah. Well, we've got him. Yeah, we've got him ready for today. Mr. Keogh, are you the prosecutor on Mr. Boykins' case?
I don't see it on any list, Judge. What's the case number or his first name?
First name is Gregory. Christina Hines.
I don't have it, Judge, now. Let me take a look.
Mr. Lakin, we've got Mr. Boykins written for today, but we did not have a scheduled hearing for today. Before we call anything, can you tell us what business you expect to accomplish today?
Well, what happened was I took over the case last week, but there was no, it's my understanding there was no scheduled date. And so just as a precaution, last week, you put it up for today, just to make sure we move the case along. So what I really like to do today is just pick a date in the later part of September. I'm going to be filing a bond motion, and I want to just make sure this case isn't forgotten, because he's going to be out. He's going to be out of the Michigan Department of Corrections in September, and then we're going to have to deal with this case. So.
Yeah,
So
and Mr. Boykins.
Yeah, I'm going to want to move the case along.
Yeah, Mr. Boykins' case hasn't been.
You cut out.
We've been having hearings on this case.
Yes, yes.
We've been having hearings on this case before you filed an appearance, so we'll make sure to get you. Bear with us 1 second.
Thank you.
Judge Matthew Penny, I hate to butt in, but did you say this was Christina Hines' case?
It is, Mr. Penny. I know she's out on leave.
I just wanted to bring that to your attention. Sorry, Judge.
I'm pretty sure that's why we didn't set a next date. We're waiting to figure out who was the next prosecutor on it. Bear with us 1 second, folks. Darren, my thought. Did we get set it? We'll set it on our normal docket because it's MDOC. We can still.
Well, he'll be out of MDOC, Your Honor. He'll be out of MDOC in September, and I'm guessing will be down at the Wayne County Jail. So, what day do you get out, Mr. Boykins? Can you hear me? Maybe you could turn up your microphone, Mr. Boykins.
He's on mute right now. Bear with us 1 second, Mr. Lakin.
Your Honor.
Yes.
This is Shakira Hawkins. While you're checking, can you make sure that you have Javon Crawford? He's scheduled today. He's an inmate in MDOC. And I don't see him anywhere on Zoom.
We have the arraignment file, but he should. We were not aware that he was. So 1 second, Ms. Hawkins.
Okay.
Mr. Lakin, we've got your client unmuted. Just a reminder, these are not confidential communications here.
Right, right. Mr. Boykins, when does your sentence end?
My discharge date is September 11th.
All right, so any date after September 11th, Your Honor. The first date after, frankly, about a week after that.
Put it on the 15th on the D docket. Mr. Lakin, we're going to set it for September 15th at 1 p.m. That'll be on the D docket.
That's perfect. Thank you, Your Honor. Thanks for accommodating.
We'll send a message to Ms. Hines' unit at the prosecutor's office to make sure we got everyone we need.
Your Honor, I am texting one of the APAs now, and I've let them know, and they'll make arrangements.
Yeah, and make sure they can contact me. Try to get a hold of them. So
we'll send out a notice separately.
Thank you, Your Honor.
Mr. Lakin, I don't think we need to go on the record for this unless there's something else you want to accomplish.
No, we're fine then.
Okay.
The 15th. Thank you. Thank you for accommodating. Thank you.
Take care. Ms. Soroki, Agent Smith, I take it you both are ready to go?
Yes, Your Honor.
Yeah, Your Honor.
Thanks for your patience.
Your Honor, if I may, Mr. Williams, I don't see him. Does the county jail have him, or do we have to waive his presence for the bond motion?
bear with me 1 second, Ms. Marable.
Of course. Thank you, Your Honor.
Okay.
This is case number 19530 and 196, like that, 191668. People State of Michigan versus Patrick Langford. He's here on violation of probation hearings in both matters.
Can the parties identify themselves for the record, starting with the probation department?
Good afternoon, Your Honor. Andrea Smith on behalf of the probation department.
Good afternoon.
Good afternoon, Your Honor. Pauline Soroki representing Patrick Langford.
Good afternoon, Ms. Soroki, and good afternoon, Mr. Langford.
Good afternoon, Your Honor.
Mr. Langford, first things first, can you hear us clearly?
Yes, Your Honor.
Okay, if at any point you cannot hear us, simply wave your hand. We'll try our best to resolve the technical.
You are cutting in and out.
We're here for a by way of background. Mr. Langford, can you hear us?
It's cutting in and out.
You're breaking up, Judge, even for me.
One second, everyone.
Thank you.
Agent Smith, Ms. Soroki, can you hear me clearly now?
I can't hear.
Ms. Soroki, can you hear me clearly?
I could hear that last line, yes.
Okay. Mr. Langford, can you hear me clearly?
Yes, Your Honor, now I can.
Okay. Okay. By way of background, Mr. Langford has a pending probation violation as it relates to both cases. There was an arraignment recently before, I believe, Judge Cusick. Excuse me, a bond motion in front of Judge Cusick. And this was the control date that was set for Mr. Langford's case. Agent Smith, can you provide us a little bit more background on this?
Yes, Your Honor. The defendant was, he was placed on tether at that bond motion. However, he violated his tether. Can you hear me?
Yes, we can.
Okay. And then the warrant states that the defendant left Amherst home prior to being medically discharged. He left February the 8th of this year, and then he failed to report to his supervising agent, Ms. Gatson, February the 10th, and also February the 21st, after home calls were made and instructions were given to him to report.
Okay. And so right now, we're simply waiting for a contested hearing. Is that correct?
Your Honor,
Yes.
I did discuss this matter with my client, and we could resolve it at this time, or they're expecting another warrant tomorrow, so I don't exactly know how the court wants to handle this.
That's right. And I guess if there's a new warrant that's coming through for additional conduct, then he needs to get arraigned on that as well. My understanding is it would be an addendum to the pending violations.
I mean, we could resolve the cases today, and then the court, I mean, if you're going to send him for a pre-sentence report during that pendency, the other, you wouldn't have to send him on the last violation.
Your Honor, I want to be clear. This information was just presented to me 20 minutes ago by his supervising agent
So
of his new arrest from this weekend.
let me ask Agent Smith, if there's new information that just got passed along to you, am I correct that the probation department is not in a position to place a recommendation on the record today?
I am, Your Honor.
Oh, okay, well, let's hear the recommendation of the probation department.
Your Honor, it's respectfully recommended at this time that Mr. Langford be sentenced to a term of incarceration, as this is his third violation, and we have sent him to substance abuse treatment 2 times prior to today.
Okay. Ms. Soroki, have you had a chance to talk about this recommendation with your client?
Your Honor, I did discuss it with my client. I discussed with him that the maximum penalties on his case are 20-year, and he understands all those, and he would, I mean, of course, you know, that's not what we would ask for, but he does understand that's a position of probation. And he would still admit if the court wants to proceed that way today.
Okay, may I make an inquiry of your client?
Please.
Mr. Langford, have you been able to follow along with everything so far today?
Yes, Your Honor.
Sir, your lawyer has indicated that you intend to admit to the pending violations. Is that in fact what you want to do?
Yes, Your Honor.
Agent Smith, to confirm, the statutory maximum penalties in this case will be up to 20 years in prison. Is that correct?
Yes, Your Honor, and that's on both dockets.
Okay, 20 years on each case potentially.
Yes, Your Honor.
Okay. Mr. Langford, I'm going to ask you a few more questions, but before I do that, I'm going to place you under oath. The reason for that, when the lawyers speak in open court, they're doing so as officers of the court. Everyone else, whether it's a defendant, a witness, or a prospective juror, has to be placed under oath. So, sir, please raise your right hand as you are able. Do you solemnly swear or affirm that the statements you're about to make will be the truth under the pains and penalties of perjury? If so, say I do.
I do.
Mr. Langford, you understand that if you admit to these violations, you'll be exposing yourself to a statutory maximum of up to 20 years in prison on each case. Do you understand that?
Yes, Your Honor.
You understand that the court could also extend your term probation or modify the terms and conditions or revoke your term probation and terminate your term unsuccessfully. Do you understand all that?
Yes, Your Honor.
Sir, has anyone threatened you to get you to admit to these violations?
No, Your Honor.
Has anyone promised you anything to get you to admit to these violations?
No, Your Honor.
Have you had a chance to talk with your lawyer, Ms. Soroki, about these pending violations?
Yes, Your Honor.
And is it your intention to admit to the pending violations?
Yes, Your Honor.
Let me ask you, sir, is it true that you left the Elmhurst Home Treatment Facility before you were medically discharged?
Yes, Your Honor.
Is it also true that you failed to report to the probation department after you were discharged from Elmhurst or after you left the Elmhurst home?
Yes, Your Honor.
I'm going to find that there's a sufficient factual basis to accept Mr. Langford's plea as knowingly, intelligently, and voluntarily made. And we're going to refer Mr. Langford for a new pre-sentence report. That's based on the recommendation from the probation department. Agent Smith, with the current pandemic protocols, realistically, when can that report be updated or prepared?
Your Honor, it can be done within the 2 weeks time frame.
Okay.
One more thing, Your Honor. I just wanted to know also on the warrant, it alleges that the defendant tried to sell one Adderall pill prior to leaving Amherst home. I just wanted to know, is that something that you wanted to ask him about?
I'm going to object to that. That would be it. You know, if my client admitted that would be admitting a felony, and I made probation aware prior to.
It's on the warrant.
What we are going to say, I think he satisfied the court and his allegations that he violated his probation.
Well, folks, one second. And Mr. Langford, wait 1 second. just so we're clear, the first item of the probation violation warrant reads as follows, quote, probationer Langford absconded from substance abuse treatment facility Elmhurst Home, Detroit on February 8th, 2020, prior to being medically discharged. Prior to absconding, probationer attempted to sell a single Adderall pill. Stop quote. As I read it, really that's two potential violations combined into one being the absconsion, and the second being supposedly a new law violation related to the Adderall pill. Folks, I'm satisfied with the admission to the absconsion and am prepared to proceed to resentencing based on that and his prior violations. Agent Smith, is there any additional objection you want to put on the record to that course of action?
No, Your Honor, thank you.
Okay, thank you for that, making sure that covered all of this. We're going to refer him for a new pre-sentence investigation report, and I'll give you a next.
What is going on, bro? I've been on mute for 2 hours. Why did I log on at 1 o'clock if I'm...
We're going to, this is a reminder to everyone on the call to maintain.
Nobody understands what I'm talking about.
I'm placing
For
Mr.
2 hours.
Pollock.
Why have I been on?
Mr. Pollock, I'm placing you on mute because you're disrupting our court proceedings.
I'm trying to figure out why y'all had me logged if I'm not going to see a judge. I should have saw a judge already. It's 3:15.
Hey, Mr. Pollock, you're speaking to the judge. You got
for the record, I've just removed Mr. Pollock from the hearing because he was disrupting the proceedings. If he attempts to re-enter the call and continues to disrupt the proceedings, he'll be held in contempt.
Your Honor, is there any way we can get an address for Mr. Langford? I'm not sure if his attorney has a valid address.
I didn't get one. I'm sorry, I forgot.
Okay.
And we don't have a date yet for the sentence.
Yeah, folks, I was just about to give you a new date before I was disrupted. Bear with me 1 second. We get 31st, 15th. This is gonna be 15th. The 31st of what? 31st of August. Oh, no. Mr. Roki and Agent Smith, we're looking at September 15th. That's our next in custody date after the two pre-sentence.
Works for me, Your Honor.
Okay, is that a morning or afternoon?
That'll be the afternoon on the D docket at 1 p.m.
Okay, thank you.
Thank you. Anything else on behalf of the, well, Agent Smith, do you want me to put you, Mr. Roki, and Mr. Langford in a breakout room so you can get the address?
Yes, Your Honor.
And I have one question, Your Honor. Is this your sentencing?
Yes.
Or we'll go to whoever's doing the D docket? I'm not so sure how that goes.
He's under judgment.
It'll be in front of me.
Okay.
It's set on the D docket because he'll be in custody, and that's the next in custody hearing date that I have.
Thank you.
Okay, thank you. Agent Smith?
Yes, Your Honor.
The warrant or the addendum on the additional matter, how does the probation department want to handle that?
It should be to me tomorrow, Your Honor.
Okay. Okay, well, folks, to make sure that he's arraigned on that, which I understand that this may seem, we've got two options. The first is to set him for a hearing tomorrow in front of one of the judges on the COVID rotation. The other option is to set it on the next date that I'm presiding on one of the COVID dockets. I guess.
Can we do the next date you're residing, Your Honor? He's gonna be in custody anyway.
I think
Or we
that
could
makes-
save it for the sentence date, unless you could just bring it back on the, well, we don't know when it's gonna be set though, so.
Yeah, so folks, here's what we're gonna do. We'll set it for August 31st. And as long as we've got him in the box and ready to go, we'll get to you first. August 31st to arraign him on the new. Before we do that, Agent Smith, do you anticipate that this new warrant is gonna radically change the probation department's recommendation?
No, Your Honor, it's actually just an alleged possession charge, no.
Okay, then we're gonna set it all for the September 15th date, and we can take care of it all in one day.
Your Honor.
Thank
Any
you.
issue with that?
No.
Okay. Anything else on behalf of the probation department?
No, Your Honor.
Mr. Roki, anything else on behalf of the defense?
Thank you, Your Honor, no.
Okay, with that, we're adjourned. Thank you. Also.
Right, he's a violator, is what he is. Sometimes, yes, let's put whatever, I don't know.
Ms. Marable, we may
Yes.
have to give you a different date. We're looking, and I'm not sure jail has Mr. Williams.
We have to ask where they're on there. Is the jail on there?
Division.
Jail is,
One second, Ms. Marable.
of course.
The individual at the jail, Division 1, can you please identify yourself?
That's Hyde, Judge. That's my case.
Okay, all right, Mr. Moxie. All right. Mr. Hyde, we're unmuting you. 1 second.
They both on the phone.
Mr. Hyde, can you hear us?
Yes, I can. Can you hear me?
Yes.
You can hear me?
Yes, we can.
Thank you. How you doing today, Your Honor?
Okay. Mr. Mara, do we have you on the line?
Yes, Judge. Good afternoon.
Good afternoon. And Mr. Moxie, you're representing Mr. Hyde?
Yes, sir.
Okay.
So we didn't need Mr. Cobb.
I think Moxie is representing him. Let me just give Marable an answer on this, and then let's call Hyde.
Okay, first, I need the jail.
Ms. Marable, we'll get you an answer on Mr. Williams right after this case, once we get the deputies back in there. Thank you for your patience. Okay, we're ready on Hyde.
This is case number 185982, People State of Michigan versus James. He's here on violation of probation hearing.
And this is off the Swift Insurer docket. Can the parties identify themselves for the record, starting with our Swift Insurer representatives?
Good afternoon, Judge. John Mara for the Swift Insure Program.
Good afternoon, Your Honor. Deborah Webb, Michigan Department of Corrections.
Good afternoon, Agent Webb.
Good afternoon.
Afternoon, Your Honor. Andrew Moxie, P number 69568 on behalf of Mr. Hyde.
Good afternoon, Mr. Moxie, and good afternoon, Mr. Hyde.
Good afternoon.
First things first, Mr. Hyde, can you hear us?
Yes, I can. I can hear you.
Okay, if at any point you cannot hear us, simply raise your hand and we'll try our best to resolve the technical issue.
Yes, sir.
Here today for a review date on Mr. Hyde's Swift Insure participation. I'll note that he has two cases. One case is in front of Judge Bazzi on 18-5982.
That's it. That's the behind. We have both. This is case number 162512. People State of Michigan versus James Michael Hyde also.
The other case is 16-2512. That's the case for which he's currently on the Swift Insure docket. Mr. Mara, Agent Webb, can one or both of you provide a brief update regarding Mr. Hyde?
Yes, Judge. This morning, Mr. Hyde appeared on the docket. I believe it was actually the emergency B docket with Judge Bazzi for a violation of probation for the same allegations and the same warrant that was addressed here in the Swift Insure Court. When Mr. Hyde entered into the Swift Insure program, his other case, the 2018 case, was not brought in to the Swift Insure program. Agent Webb has been supervising that case as well, but it just has not been subject to the Swift Insure program. And Judge, this morning in that hearing, I was also present and recommended that Judge Bazzi order Mr. Hyde into the Swift Insure program on the 2018 case, and she did then adopt that.
Okay. And
Today, Judge, I apologize if I talked over you.
Go ahead, Mr. Martin.
Yes, Judge. Mr. Hyde was set for a status review on the 16 case anyway, because he was arraigned by Judge, I believe, Regina Thomas earlier in the month. And the last time we attempted to do a status review, the jail was unable to bring Mr. Hyde, and that's why we are here on this date. But since we are, we now have a new case to place into the Swift Insure. I'm unsure if a warning hearing is necessary, Judge. I guess I would just leave that decision to the court.
Okay. And to be clear, the Swift Insure program, for new participants, a warning hearing is required by statute to make sure that the participant is aware of the potential sanctions associated with the Swift Insure program. Because Mr. Hyde has already been participating in the program and a warning hearing has already taken place, unless I'm hearing a strong objection from Mr. Moxie on Mr. Hyde's behalf, my impulse is to simply incorporate by reference the prior warnings that Mr. Hyde received. Any issue with that, Mr. Moxie?
I like your impulses, Judge. We're going to go with that.
Fair enough. Okay.
And Judge, with Judge Bazzi's order this morning, the 2018 case was extended for 12 months from today. And being that Mr. Hyde was absconded from this program for a period of 400 and something days, you know, I believe if we tried to do another 12 months with Mr. Hyde and Swift Insure, that we could benefit on both cases and work on the same issue.
It's simply starting from scratch, as it were.
Yes, Judge. You know, typically I would recommend a 30-day sanction because that is on the sanctions grid as the prescribed sentence for absconding.
At this point, Mr. Mara or Agent Webb, how much time has Mr. Hyde had in custody? Because he should be close to that 30-day sanction.
About
One second. Check our end as well.
Judge, I could continue to reign.
One second. Mr. Hyde, we'll turn to you at the end of the hearing. Now, the reason I stop you is not to be rude, it's so that you don't say something that jams you up at a later date. Give us one moment.
Yes, sir.
Judge, I can only say that he was arraigned on August 10th with Judge Thomas. So I would anticipate at least a day or two before that he was arrested, but I don't have that exact information in front of the judge.
That's fine.
Perhaps Agent Webb does.
Unfortunately, I do not have a date. I don't know.
Okay.
10 to 12 days if I'm estimating, Judge.
Okay,
Maybe-
folks, bear with me. Bear with me 1 second. Okay, Mr. Mara, I cut you off. You were saying that the typical sanction you would recommend for an absconsion, particularly one with over a year, would be approximately 30 days in Wayne County Jail.
I mean,
Is that the recommendation today?
it could be, depending on if there were other circumstances. There's been nothing found in the lien in this particular case. There is more treatment that we would want to try to do with Mr. Hyde. So other than just revoking him from a program, that would be what I would ask for, Judge.
Mr. Moxie, is your client admitted to the absconsion?
He does, Judge.
Okay. Mr. Hyde, have you been able to follow along with us so far?
Yes, sir.
Your lawyer indicated that you intend to admit that you absconded from the program and failed to report. Is that what you want to do?
One more time, I'm sorry.
Your lawyer indicated that you intend to admit that you absconded and failed to report. Do you intend to admit to that?
Yes, sir.
Excuse me, Your Honor, you're breaking up. This is the court reporter, you're breaking up.
Okay, Ms. Rhodes, give me 1 second.
Okay.
Ms. Rhodes, can you hear me now?
Yes.
Yes. Okay. Mr. Hyde, please raise your right hand. Swear or affirm that the statements you're about to make will be the truth under the pains and penalties of perjury. If so, say aye.
I do, yes, sir.
Mr. Hyde, is it true that you absconded from supervision, that you failed to report?
Yes, sir.
And you can put your hand down, that's fine. Mr. Hyde, what happened?
I pretty much missed a reporting date to, I want to say Miss Bennett, or it was Miss Webb. But I called, I had a hard problem with transportation, and I had to ride the very next day. I showed up the next day, and I believe it was Miss Burnett. And she sat me down, said she set me up a court date, and I was worried about spending jail time, and I didn't make it to court, and yeah, I continued, living my life until, basically I got caught back up here in the court in the jail. That's the truth. And I'm here now to resolve this problem, hopefully be reinstated, and continue on the Swift Insurance program. And I got opportunities out here. I got new family, not new family, but I got family members that's close to here that can help me out with transportation and anything I need. And the courts on the other case had my address and phone number for it.
Mr. Hyde, you understand that Swift Insurer, it's not just about sanctions, but their Agent Webb and Mr. Mara and the entire team can assist you with things like transportation. You understand that, right?
Yes, sir. Yes, sir. Yes, Ms. Barnett they were helping me out with bus tickets and Speedway gift cards if I got a driver that drove me there. That did help. But there was times where I got to take two different buses, two different name buses, like you got the Detroit D-Dot and then you got the smart buses downriver. And I had to pay, and the card only worked for D-Dot buses. So, and I wasn't working right away, and I just couldn't get down there one day. I was reporting down here twice a week, dropping twice a week, dropping clean, and reporting both times a week. And it's just transportation is what messed me up.
Thank you, Mr. Hyde. Mr.
Thank you.
Mara, anything to add?
Yes, Judge. I do have a suggestion for Mr. Hyde. For one, I do need to clarify his address and phone number because the earlier connection was very spotty and we couldn't quite hear everything. We can figure out how to do that, Judge. But previously, he was ordered to participate in the Detroit Recovery Project. He's now living in Warren, from what I understood earlier. And there are 2 locations the Detroit Recovery Project has that would be accessible to him on that side of town, more or less, that I think we could help facilitate happen. And I think he could benefit from Detroit Recovery Project. That is a place where we have the ability to do some drug testing, which we are short on right now in the program, Judge. And you know, if he would be willing to do that, I think he could benefit, Judge.
Well, I think considering the 2 options, one being a potential 30-day jail sentence and the other being participation in the Detroit Recovery Project, I imagine that Detroit Recovery Project would be preferred of those 2. Mr. Moxie, anything to add on behalf of the defense?
No, I agree with everything John had to say.
Okay. And I'm going to accept Mr. Hyde's admission to the underlying offense. He appeared to express contrition and self-reflection. If there's no objection from the defense, I'd like to proceed immediately to sentencing along the lines of the recommendation that was just provided by Swift and Short.
Please, Judge, please.
Okay. Mr. Hyde's going to be sentenced to time served plus placement in the Detroit Recovery Project, and specifically the Detroit Recovery Project location close to Warren, Michigan. And that'll be at the direction of the probation department. So again, since the time served, which as I calculated, it appears to be about 12 days in custody, plus drug treatment at Detroit Recovery near Warren, Michigan, and continued participation in the Swift and Shore program. Anything else today on behalf of the Swift and Shore stakeholders?
Judge, is it permissible for the address and phone number to be given?
Mr. Moxie, we've done this a number of different ways. Some folks will provide it over the Zoom call. We can also put you in a breakout session. What's your preference?
He's ready to tell you right now, Judge.
Okay, Mr. Hyde, what's your current address?
27223 Dover Ave. That's Dover Avenue.
Okay.
And like he said, it's in Warren, Michigan.
Phone number 2, please.
What's your phone number, Mr. Hyde?
1-586-630-9112.
Thank you.
Okay. Anything else today on behalf of the Swift and Shore program from either Mr. Mara or Agent Webb?
Nope. Thank you, Your Honor.
Thank you. Anything
Your
else?
Honor,
No,
Your Honor,
Judge.
this is Agent Graham from the Department of Corrections. Can you tell me what the date the defendant is continued to?
Should be 1 year from today. Mr. Mara or Agent Webb?
That is correct, Judge.
Thank
So that will
you.
be August 20th of 2021.
Thank you.
Thank you. Mr. Moxie, anything else on behalf of the defense?
No, Judge.
Okay. Mr. Hyde, did you understand what happened here?
Yeah, I understood pretty much all of it, other than now the treatment center, is that a inpatient, outpatient?
It is an outpatient group session with individual stuff available as well. What I would say, Mr. Hyde, is that we will be reaching out to you over the next few days and upon your release and help facilitate this. You'll be getting
Absolutely.
reported.
All right, thank you, I appreciate it.
Yes, sir.
Okay, with that, we're adjourned. Good luck to you, Mr. Hyde.
Thanks, Judge.
Thank you.
Darren, if you could just try to work some magic on that computer too, because they didn't have my attendance at the last hearing.
Thank you, Judge. Thank you, Mr. Hyde. Thank you, Mr. Mox.
Thank you. Thank you,
Thank
bye.
you.
Moxie, 1 second.
Okay.
Go ahead. He's still there.
Oh, Mr. Moxley, you're gonna have to call that courtroom. I can't put you in for them.
All
Or
right,
somebody
I
else.
got you. Yeah. All right. Maybe if you hit it today, it'll click, but I'll follow up with them. Thanks.
I already got you in. I already did.
Okay.
All right.
Okay, cool. Thanks.
Am I done? Yeah. Am I done here or?
You're done, Mr. Hyde. You can tell the deputies that we're done with your case.
Okay, thank you, Your Honor. Thank you, everybody. Yes, sir. All looks good. Why do you want to leave this plan standing? I give you a lot of reasons. All right. I don't have how long.
Pompey and Penny. To the deputies in Division 1.
Can you repeat it?
We still have the deputies.
Are deputies on here?
Yeah, please grab a deputy, please. Division 1, Judge Hood.
Norbert Jones.
Okay. Mr. Jones, can you knock on that door and the deputy come back?
Can you repeat that?
You ask the deputy to step in. And come in there where you are. We need to speak with him. Ask the deputy to come in there. What else do you have in Division 1?
Your Honor, I got Mr. Norbert Jones.
Yeah, that's him. Who else?
Let's see. Your Honor, I think he's the last one. Oh, wait, we have, no, wait, Piera, you waived his presence, right?
Who?
Piera, P-E-R-R-I-A.
That wasn't on our document. Didn't have.
Oh, okay. Okay. Yeah, Mr. Jones is the last one.
Calling for a gallon, but wait, I'm on this floor.
Deputy, do you happen to have Raymond Stewart in Division 1 there with you?
Stewart. He's not on my list, but I'll take a look.
Thank you, sir.
And Deputy, can you also check for Sharif Shoaib?
I'm trying to ask you, Ms. Fanny.
I appreciate you. Can you also ask for Jamie Williams?
I'm in the process of asking him who we have. Just hold on.
Okay, thank you.
Sorry, Darren, I got that started. My bad, man.
Okay, so Maurice Stewart is in the old jail. But those deputies have gone home for the day. Is there anybody else?
So all you have is Jones and Stewart.
I just have Mr. Jones here. Mr. Stewart's across the street at Division 2. But the officers over there at Division 2, they've already gone home for the day.
We reset that to the date that we reset the chair. Okay. Yeah. And then Crawford. He's in prison. Okay. Rick. Let me. Mr. Plumpy and Mr. Penny.
Yes, Judge.
It looks like, yeah, it looks like there's a mix-up as it relates to Mr. Stewart. We're going to reset his date for the same date as Mr. Cherry's final conference. And we can give that to you right now. Give me 1 second. I think we just put it in on the wrong day. Did we update Cherry's date yet?
Yeah, both of them in there. That's why I had a file and here on the 23rd.
Yeah, but I thought Cherry asked for a new date.
Yeah, Cherry, we set for the 31st, Your Honor.
Okay. Mr. Penny, Mr.
Yes,
Plumpy,
31st,
we're going
sorry.
to put Mr. Stewart on the 31st as well. Sorry for the mix-up and have you guys waiting here. It was just we got our dates messed up today. So we're going to set Mr. Stewart's final conference for the same date as Mr. Cherry. That'll be on the 31st.
Okay, Judge. He was bound over on August the 4th. So we're a little past 2 weeks at this point anyway. But the fact he's in custody, I mean, I guess that's not a big deal. That shouldn't, because he's on a parole hold anyway, and he's still on a hold for the other case, right?
He's coming through that he needs to get arraigned on. That's why we had him still on this date. Folks, hold tight 1 second.
They haven't sent us the case.
Okay.
I don't know if the case has been bound over to upstairs.
Okay. Stewart. Raymond Stewart. Miss Marable.
Your Honor, if I can do the motion and waive the client presence, I prefer that. Because he is in jail and I'm trying desperately to get a bond for him.
Okay, then we'll get to you right after Mr. Jones' case. Bear with us.
Take your time, Your Honor.
And Miss Hawkins.
Here's what I found on the web.
I'm here.
Give us 1 second just to check on Mr. Crawford.
Okay.
Mr. Crawford is the one at MDLC.
Yeah, that's what she said. Yeah, we have the file must be in the back.
Okay. So let's,
No, I'm talking about it was scheduled for yesterday.
yeah. Okay.
But I don't know if another judge did it on the COVID docket or not.
No, I'm certain that they didn't. So we can put it on for tomorrow's COVID docket. Or Mr. Plumpy and Mr. Penny, we've got a couple options. My initial impulse was to just set this over, just thinking in terms of the final conference, was to set this over for the 31st, but we do need to get Mr. Stewart arraigned as soon as possible. So one option is to put this on. We probably missed our window for tomorrow's COVID docket, but we can put them on for Mondays. Any glaring scheduling conference for tomorrow or Monday?
That would be Monday at 1 o'clock. That would be fine. Because and you know, in light of the fact you can't take us tomorrow, Monday would be fine for me. 1 o'clock.
Well, that's different.
Ms. Fanning, sorry, you're talking about Mr. Stewart's case?
No. I thought you said Miss Fanning talking about. I'm sorry. I thought you were talking about my client, Mr. Show. It was scheduled for final conference. He is in custody at the jail, and I don't know if Darren knows whether or not they have him.
We'll get to you in 1 second, Ms. Fanning.
Okay.
Just one.
Thank you.
Mr. Plumpy and Mr. Penny, I was saying there's a couple options we have. One is to try to get him on for the COVID docket, one of the COVID dockets for tomorrow, or more likely Monday. And I think that's my preference, to just get him arraigned as soon as possible in the new case, and then bump the final conference to the 31st.
Yeah, if I may, maybe Monday would be best, just to make sure we've got enough time to get the machinery working to get him.
I think Monday is more realistic than tomorrow at this point. Mr.
That's
Plumpy,
fine by me.
any issue with that, Mr. Plumpy? Mr. Plumpy, I need you to unmute. Any issue with Monday, Mr. Plumpy?
Yes, Monday's good, Judge. Just
Okay, we'll send this case to court administration. It'll be placed on one of the COVID dockets for Monday, and both of you will get a notice about the arraignment. So sorry about the confusion and the wait.
that's okay, but is that at 1 o'clock or 9, Judge? Monday.
We don't know yet. It'll be placed on the one of the 4 COVID dockets, so it could be
Okay.
either at 9 o'clock or 1 o'clock.
Okay, well, I'll check it. Thank you.
Thank you, Judge.
Okay, thank you. Take
All
care.
right. I'll call you, Matt, about those other issues.
Sounds good.
Bye-bye. Thank you. Bye-bye.
Ms. Hawkins, your client, Mr. Crawford, is in MDOC, correct? Ms. Hawkins, are you still on the line? Okay. Hawkins isn't responding, but I think her guy is in MDOC. So once she comes back on, we'll take. Let's go ahead and do Jones now.
Is Ms. Soroki still on? You got a point somebody. Because that's a courteous. Okay. From a calendar conference back in January 17th.
Ms. Soroki, are you still on the line?
Yes, Your Honor, I am.
Okay, we've got Mr. Norbert Jones on a failure to appear.
Ours, and then they take it yesterday in the Apple.
Okay. Technically, it's 2 failures to appear. So let me, we'll put you in the breakout room if you want to speak with Mr. Jones. Let me see if we can get you some paperwork here. Okay. Mr. Roki, do you want to speak to Mr. Jones in breakout room first?
I need to know what the charges are. You know, I kind of need to see the information at least.
Yeah, give us 1 second. We'll send that your way.
Okay, thank you.
Aaron. Mr. Roki, we'll be sending that your way momentarily. Bear with us.
Thank you. Thank you.
Yeah. Ms. Hawkins, are you still on the line?
I'm here. I just had to charge
Ms.
my phone.
Hawkins, okay. Just to confirm, your client's in the MDOC?
Correct, Bellamy Creek facility.
Okay. That's the issue. It doesn't appear that anyone writted him for today's hearing. So we'll send a writ to MDLC. Their typical turnaround time is 5 days. And so look, by my count, that would put us 5 business days. By my count, that would put us on 27th. What's your availability for that day?
Let me check. I just have a PCC that morning, so that's fine.
Okay. All right. So we'll send the writ request to MDLC and it'll be placed on the COVID docket, likely docket C or D, because we're going to mark down 1 p.m.
Okay, thank you.
Thank you.
Bye.
This isn't. I don't think March. Well, we'll send it to court administration. They need to do a writ to get here 5 days from now or 5. Tricky because for everything else on the COVID docket, it's folks that are in the jail or folks that individual judges have set themselves. For folks that are in MDOC,
Your Honor, is there a prosecutor on Mr. Jones?
Hey, Mr. Oki.
Hi, how are you? Maybe we could just go in a breakout room for a minute. That might be helpful.
okay, one second.
Thank you. Thank you, Your Honor.
Thank you.
Judge,
Yes, Agent Graham.
just questioning, is Mr. Pollock somewhere in a waiting room or he was just kicked out completely?
He was kicked out completely because of disruption. So we'll set that for another date. I'll send that to court administration, but
Well, I'm kind of confused because it's on the docket for an emergency bond motion, but he clearly was not in custody.
right. So we're going to send an update to admin to let them know.
But he does
like,
have an active warrant in the system, so.
That's my case that I've been waiting on.
okay, Mr. Wallace, if you want to try to get a hold of your client, we can get to him, but I can tell you, everyone else is waiting. I understand that it's frustrating, but it got to a point where we couldn't accommodate the disruption. So
I understand that, Your Honor. I understand. I'll try to get in touch with him and have him sign back if the court will allow him back in. Or I can waive his presence. Or I can just waive his presence. I'm just trying to track the new case.
So you can have him, if you can get a hold of him and have him sign back in and maintain decorum, that's fine. If you don't think that's possible, we'll set it for a different date.
Why don't we just set it for a different day? I just want to set aside the warrant and track the new case. That's all I was trying to do in the first place.
You need him to appear in order to set aside the warrant. So
Okay, I'll try to get in touch with him.
We'll take care of this other case, and then hopefully we can. Ms. Marable, it looks like again, with the jail, you're fine with. Sorry, you're on mute, Ms. Marable.
Okay, I'm sorry.
Okay. So we're going to take care of one other case, our last in custody case, and then we'll call yours after.
Okay, I'm gonna charge my phone. Thank you.
Thank you. And then we've got Fanning here on Rob. Yeah. Ms. Fanning, are you still with us?
I am, Your Honor, yes.
Okay, thank you for your patience.
Thank you. You've had a long day. You've been very patient with everyone.
We're all trying to make heads or tails of this, so it's all new. So it looks like there's some mix-up with Mr. Schwab's appearance from the jail. I guess one of the divisions concluded earlier. So let me give you another date. And give me 1 second.
Thank you, Your Honor.
Ms. Fanning, how does your calendar look for August 31st at 9 a.m.? That's the B.
Your Honor, because this was a bond motion in addition to a calendar conference that was put over from the AOI last week, can we do it on Monday if at all possible? I mean, it's your case, and that's why they put it over.
If you're willing to waive his appearance,
I
you
am.
can do the bond motion today.
Okay, I am. Thank you. Thank you.
We got one or two other things, and then we'll do yours right after that.
Your Honor,
Yes, Agent Graham.
for Ms. Fanning's case, it doesn't appear that the defendant was arraigned on the VOP matter. The case he's on, he's active in your court too. He has a VOP warrant that it doesn't appear he was arraigned on.
1 second.
Okay.
Folks, bear with me 1 second. Ms. Fanning, because he's still got a pending warrant for probation violation,
Yeah.
he has to get arraigned on that in addition to address bond on the other case.
Okay.
So realistically, Monday would be the earliest date to get him arraigned on the pending violation.
Okay.
To the extent that you're asking for reduction and bond on the other case, we can still do the hearing. But we wouldn't be able to arraign him on the probation violation. So even if we reduce bond, it would still end up, we'd still have to come back in front of the court and probably.
Exactly.
until
Exactly.
Monday.
So will we be
So-
able to do both on Monday or no?
The short answer is yes, it just wouldn't be in front of me. It would be in front of a different judge on the COVID docket.
So with that being said, I need to have it on your docket because all of the other judges are deferring to my trial judge, which is you. So whatever date, the first available date you have, please.
Okay, okay. Ms. Fanning, our next date that I've got one of the COVID dockets is August 31st.
Okay.
I don't like him sitting around that long. So here's what we'll do. We'll set it for the 31st for now. I'm gonna
Okay.
reach out to Judge Edwards. At times they'll let us put, at least every now and then, they'll let us put one of our cases on someone else's COVID docket.
Okay.
So let me see if I'll ask for permission to see if we can put that on an earlier date.
Okay.
Are there dates next week? Specifically, I'm looking at Monday or Tuesday of next week that don't work for you?
No, I can do either Monday or Tuesday. I'll make it work for me. Thank you.
Ms. Fanning, what's a good email address for you?
It's my name, Andrea Fanning at yahoo.com. AndreaFanning at yahoo.com.
Okay.
Thank
Look for an email from the court probably tomorrow morning. I'm going to reach out to Judge
Okay.
Edwards if there's something we can accommodate, just considering the circumstances. So look for an email from us
Okay.
sometime tomorrow. Yeah.
Thank you so much, Your Honor. Thank you.
All right.
Your
Thank
Honor,
you.
Your Honor, I've spoken to my client, and he's apparently going to be able to maintain decorum while in the court. Did you block him somehow for him to not be able to sign back in?
I removed him from the conference, so I don't know if that means that he can't now get back in. Which one? No, that's Marable. Yeah. Did he indicate to you that he's trying to rejoin the call?
Yes, he's. I asked if he's able to sign back in, and he said no.
Okay, bear with me one second.
Yes.
Okay. I think so. Yeah.
They're not going, they shouldn't put the other cases on there.
Yeah.
They're at least going to put that violation in Judge Lillard's courtroom just caught, and Fleming, they see the docket for tomorrow, and Fleming got known it. Thought they were going.
Okay. All right.
Judge, at your
Yes, Mr.
convenience, I could go in a breakout room with Mr. Jones. I talked to
Okay.
the prosecutor, so I've got enough understanding.
Okay, bear with me one second.
No problem.
To a breakout room right now.
Okay, thank you.
All right. Give me 1 second, Darren. Let me see if I can get back in here.
And I'm asking if there's someone near him where he could probably try to use a different device if that would help, but I don't know if he does.
Looks like I have to modify our settings to do this. Just give me 1 second and I'll see if I can. Mr. Keogh, while I'm working on this, are you the prosecutor on the Jamie Williams case?
Yes, Judge.
Okay, the defense is going to waive his appearance, so we may go ahead and do that while Ms. Soroki is in the breakout room. Darren, give me 1 second. Ms. Marable, are you still on the line?
Yes, I'm still here.
Okay. Mr. Keogh, are you all set?
Ready, Your Honor.
Okay, go ahead, Darren.
This is case number 18-3314, People State of Michigan versus Jamie Williams, here for a bond motion.
Can the parties identify themselves for the record, starting with the prosecution?
Yes, Your Honor. Good afternoon. My name is James Keogh, P82812 on behalf of the people.
Good afternoon. Okay, excuse me. Good afternoon to this honorable court. Carla Marable on Mr. Williams' behalf, P number 62755. Your Honor, if I may I waive Mr. Williams' presence?
That's fine.
Your Honor, this is the defense motion for a bond. As I know, the court is very well aware of the worldwide pandemic. Mr. Williams is currently charged with assault to commit murder and felony firearm, which I know are very serious cases, and this case is also old. But one of the things that happened is the case originally happened, and I wasn't the attorney on the case when it originally happened. After that, Mr. Williams was in a near fatal car accident. And because of that car accident, he is partially, he's paralyzed on his left side. He's partially blind. He has a history of respiratory problems along with some other issues. We're just asking, because I know that the purpose of bond is twofold. It's for the protection of society, and it's also to make sure that a person shows up for court. I think that at this point, he meets both criteria. I don't think because of his health challenges, he's a threat to anyone. He's paralyzed on his full left side, Your Honor. He's not a threat, a physical threat to anyone. And I don't think that he is a flight risk. This morning, I emailed the court, and Mr. Flowers acknowledged that he did get it, his financial statement. He has limited resources. The person that's going to pay the bond is a first cousin who just, hates to see him in jail. Over with me taking the case over in July, even in the 8 weeks that I have been there, I have seen Mr. Williams deteriorate. We're just asking for a reasonable bond during this worldwide pandemic.
And before I turn to the prosecution for response, Ms. Marable, how much is the cousin willing to put up towards the bond?
The cousin told me that he had 2,500.
Mr. Keough, the people's response?
Well, Your Honor, I disagree entirely that Mr. Williams is not a flight risk. He was in CAPIA status for over a year, and this was after he had gotten into that serious car accident. We may very well have been able to finish this case in the time that he had CAPIA, and instead we're here by no one's fault but the defendant's. That's in addition to the fact that he is facing significant jail time, prison time, if he is convicted on any one of these charges. So he's a flight risk. He's facing significant prison time. He was in CAPIA for over a year. I don't think the bond is unreasonable. He didn't come in through the front door voluntarily. He had to be picked up to be brought back. And so if this court is going to set a bond, we ask that a high cash value be assigned to ensure that the defendant attends future court proceedings, and also some sort of tether to make sure that he does show up. Thank you.
If I
Thank
may,
you.
Your
Ms.
Honor,
Marable,
I have
last
no
word, Ms.
objection
Marable.
to. I have no objection to that tether. I disagree with the prosecutor, and I previously had emailed the prosecutor, and he will acknowledge his medical records, which is enormous, right? He, after being in a near fatal car accident, he was in what do you call it, therapy, when you learn to walk and talk again, for over a year. So he might have technically been capious, but he never was on the run. The prosecution has proof, and they're not, I think, denying that he was in a near fatal car accident where he was in physical therapy for over a year to learn how to walk again and how to talk again. So I think that the capious status in this particular situation is a misunderstanding. He's in the car accident, so he's not able to keep up with his court dates because he's in the hospital originally, when you look over the medical records, for like 6 months, and then he's in rehab for another 6 months, and he's going back and forth to rehab for over a year to learn how to talk again. So I think that it's a it's a mistake. And only thing that we're asking, because of his significant health issues, which I don't think the prosecution is denying, because I turned over his recent medical records when I did a gun board letter, he's not a flight risk. And with a tether, and also I tried to get the cousin on the phone, and I have explained to the cousin that if you do give him a bond, that he has to make sure that he shows up, unless the cousin will be on the lack of a better word, will be responsible for the cash bond. So we're just asking for a reasonable bond.
I appreciate the arguments of both sides, and I've taken into consideration, among other things, the financial affidavit the defense filed at the court's request, or provided at the court's request. I'm guided by Michigan Court Rule 6.106, and relying on those principles, taking into account Mr. Williams' health condition, taking into account the COVID-19 pandemic, and taking into account his prior conduct while on pretrial release, I'm denying the request modified bond to remain on remand status. The frank reality of this case is there's only two considerations I really have to focus on. One is the risk of immunity, and the other is the risk of non-appearance. Here, in most cases, the risk of non-appearance is speculative. Different matter if it were a less serious case, but you don't just forget an assault with intent to murder case. I understand that he may have been in some form of occupational therapy or rehabilitation, but the reality is this is not the sort of case someone forgets about. It's a case they choose not to show up. For those reasons, even in light of the COVID-19 pandemic, I find that there is not a single condition or combination of conditions that can reasonably assure me that Mr. Williams would show up as required. For those reasons, I'm denying the motion for modified bond. Anything else today on behalf of the prosecution?
No, Your Honor, thank you.
On behalf of the defense? Ms. Marable, anything else on behalf of the defense? Now, note for the record, it appears we've lost Ms. Marable. In order indicating the court decision today. And with that, we adjourn.
Thank you, Your Honor.
Thank you. Roku, still have you on the line. Ms. Soroki, are you still on the line?
No, yeah, I'm here, Your Honor. I spoke with my client, I spoke with the prosecutor, so we're ready, I guess.
Okay.
I know we're at the late hour, it's 4:20, so I imagine we'll just get another date at this point.
Bear with me 1 second. Let's go ahead.
This is case number 19-4058, People State of Michigan versus Norbert Jones. Mr. Jones is here. The case is from a calendar conference on January 7th. Also has docket 188598, number 2. And that matter is off the docket of the Honorable yesterday on the 19th on a violation of probation.
Your Honor, the clerk is breaking up.
Okay. Ms. Rhodes, can you hear us clearly now?
Yes, I can hear you clearly.
Okay. Again, we're here on two cases for Mr. Jones, case 19-4058 and case 18-8598. Can I get the parties' appearances for the record, please?
Good afternoon, Your Honor. Andrea Smith on behalf of the Probation Department.
Good afternoon,
Good
Agents.
Sorry, Your Honor. Good afternoon, James Keogh, P82812 on behalf of the people for case number 4058.
Good afternoon, Mr. Keogh.
Your Honor, Pauline Stroke, newly appointed on behalf of Mr. Norbert Jones.
Good afternoon, Ms. Soroki. And I'll note one of these cases is in front of Judge Thomas Hathaway. The other case is in front of me. We were last here on my on the case 19-4058 on January 8th, 2020. And there was a failure to appear. There's a failure to appear on both the 2019 case and yesterday a capias entered on the 2018 case. From looking at the file, it appears that the capias on the 2018 case entered error based on Mr. Jones being in custody already. So we'll start by setting aside the capiases on both matters, and Agent Smith, has Mr. Jones already been arraigned on the probation violation?
Yes, Your Honor, on 18-8598.
Okay, okay. And it's showing on our side that he's been arraigned on that as well. So we'll give everyone new dates as it relates to Mr. Jones. Ms. Soroki, is there any requests to reinstate or put in place?
My client indicates that he has had some medical issues and he's had some other problems. He understands the importance to coming to court. Indicated he's scheduled to have a surgery on his neck, that he had had a tube inserted in his neck and it broke through. And so he has some medical situations going on too. And he states he's living with his mother. I'd ask the court to allow him a personal bond at this time.
Let me hear first from Agent Smith, and then if Mr. Keogh has anything to add. Agent Smith?
Your Honor, we will also recommend a GPS tether at this time. And if there's any way before we get off the record, I can get a valid address on Mr. Jones.
Okay, but not as long as there's a GPS tether and a suitable address, not any strong objection to reinstating some sort of bond.
No, Your Honor.
Mr. Keogh, anything to add on the bond issue?
No, Your Honor, I agree that a GPS tether should be added in this case.
I'm inclined to agree. The notes that I'm looking at in this case indicate, among other things, some mental health issues that may have been contributing factors. I'm going to grant the defense request to reinstate a bond, and we'll set this as a previous bond. Yeah.
Your Honor, also the defendant is defendant 2 in this matter. It's 859802.
On the 2018 case.
Yes, Your Honor.
Yeah. Okay.
Your Honor, if I may, my client is back on, and he's under what's the iPhone that has the volume muted.
Okay, we'll get to his case after we're done with this case and one other. Thank you.
Thank you.
Probably a personal bond.
No, not on ours.
No.
But that was a child in the back.
Okay.
On the personal one, Judge Edwards put him on a personal. On the other case, it says he put him on a personal with a GPS tether with a house arrest. He's the one that arraigned him on the probation case.
Okay.
And then he told him he had to zoom in on what. But
Got
like
it.
I said, I don't know if he got out or not. I'm not sure.
Okay.
I'm just curious.
Folks, bear with us 1 second.
Thank you, Your Honor. While we're waiting, can I ask my client for his address? Would the court be all right with that?
That's fine.
The original was 2,010%, and it says.
Mr. Jones? You got to unmute. We need your address and your phone number, please.
We're trying to unmute him right now. One second,
okay.
Mr. Rowe.
Thank you, Judge.
And Your Honor, my phone went dead. I didn't want you to think that I went off it because you ruled against me. I just wanted you to know my phone went dead. But I did get your ruling.
We've got another going on right now, but we'll get to you in a second.
Okay.
Okay, Mr. Jones, can you give us your address, please?
8062 Artesian Street, Detroit, Michigan, 48228.
And do you have a phone number?
My mother's 313-658-5741.
Okay, I'm going to text her my number.
Okay, thank you.
Okay, so just, yeah, we're going to go back and wait for the court now. Thank you.
Okay, we're going to reinstate the previously set bond, which was $3,000, 10%. We're going to add a condition of a GPS tether with a requirement of house arrest. He'll be able to leave the address upon notifying the tether agent, obtain necessities like groceries and medicine, to obtain medical treatment, and to meet with his attorneys and investigators. Otherwise, he'll be on house arrest at the tether location.
You said
Also gonna
$3,000,
reinstate
10%?
$3,000, 10%, which is reinstated. That was Mr. Jones' prior bond. We're putting it back in place, adding a GPS tether. We're also gonna reinstate the bond on the 2008 case, which also required GPS tether and house arrest. We'll set a next date for Mr. Jones. September 4th, 1 p.m.
Thank you, Judge.
No thanks
Judge,
required.
will this just be a special pretrial?
That'll be a special pretrial and continuation of the calendar conference. We'll set additional dates at that time.
Thank you, Judge.
Thank you. I'm gonna.
Let me give you a new date for Judge Hathaway's case. Give me 1 second.
Your Honor, that wouldn't be my case because somebody's already appointed on that. I mean, the violation, we didn't do the violation today.
Well, I'm reinstating comment on the violation as well.
Oh, all right.
In the 2008.
Okay.
Agent Smith, my read of it, it makes sense just to have the two cases track each other, correct?
Yes.
So we're just gonna set the same date for both. And I understand it's in front of Judge Hathaway. As long as you all appear in front of me, we'll send an email to Judge Hathaway's chambers to make sure that they're aware the date will be September 4th.
Yes, Your Honor.
We'll just sign in with you, Your Honor, correct?
Sign in with me at 1 p.m.
Thank you. All right, thank you.
Thank you, Your Honor.
And with that, unless there's anything else from either side, we're adjourned.
Thank you, Your Honor.
I'm gonna sign out now. Thank you, guys.
Thank you.
Take care. Mr. Jones, you can tell the deputies we're all done with your case. Ms. Marable, you cut out earlier, but we wrapped up the hearing. I'll make sure that you get a copy of the order that we enter.
Thank you. My phone went dead. I didn't want the court to think I was being disrespectful. The phone went dead.
Not at all. Thanks for your patience. Okay.
Thank you. Bye-bye.
All right. And then Pollock. Mr. Wallace.
Yes, Your Honor.
Ready on Pollock?
Ready, Your Honor. I believe he's on the iPhone, the iPhone.
Okay. And Agent Smith or Agent Graham, which of you are the agents on this case?
Agent Graham, Your Honor.
Okay. Okay.
And Your Honor, I think that was it for me, so I'm gonna say goodbye now before you start.
All right. Thanks, Mr. Keogh. Take care.
Thank you, you too. See you, Darren.
All right. See you then. This is off the docket of the Honorable James Shalinsky. This is case number 19-5151, People State of Michigan versus Edmund Pollock, here on a violation of probation.
Can the parties identify themselves for the record, starting with the probation department?
Good afternoon, Your Honor. Agent Graham appearing on behalf of the Michigan Department of Corrections.
Good afternoon, Agent Graham.
Good afternoon, Your Honor, and good afternoon to your staff. Ted Wallace from the Perkins Law Group on behalf of Mr. Pollock, who I believe is present under the name of iPhone in the hearing.
Good afternoon, Mr. Wallace, and good afternoon, Mr. Pollock.
Good afternoon.
First things first, Mr. Pollock, can you hear us clearly?
Yes.
Okay. If at any point you are not able to hear us, simply raise your hand. We'll try our best to resolve the technical issue. Do you understand?
Yes.
We're here today for an emergency bond motion that's been filed in case 19-5151 and an arraignment on the alleged probation violation. Specifically in the warrant that I'm looking at, I'll start by summarizing the alleged probation violation, then I'll turn to the defense to confirm that the defense has received written notice of the alleged violation. Based on the violation that I'm looking at, one violation identified, it's a new law violation. Specifically, it's alleged that per a Detroit police investigators report on July 22nd, 2020 at approximately 8 p.m., Mr. Pollock was arrested for possession of a handgun at a Marathon gas station located on West Chicago and Detroit. The arrest occurred after the police received a radio transmission indicating that there was someone with a concealed handgun at the gas station. After approaching the car, they observed Mr. Pollock smoking, or the driver smoking near the gas pump. The driver and Mr. Pollock, who was in the front passenger seat, were detained. After a search of the vehicle, the police recovered 2 Glock Model 19 handguns with 10 and 14 live rounds in the vehicle. Both individuals were arrested for carrying a concealed weapon in a motor vehicle, and a passenger in the back seat was released. Turning to the defense, Mr. Wallace, have you and your client received written notice of the alleged violation?
We have, Your Honor.
Okay. May I briefly address your client?
Yes, Your Honor.
Before I do, Mr. Wallace, you're retained on this matter?
I believe my partner Muhammad Nasser from the Perkins Law Group is retained on it.
Okay, but the Perkins firm has been retained as counsel.
Yes.
Okay. Yes. Mr. Pollock, I want to start by informing you of one right that you have that sticks with you from start to finish, and that is the right to counsel. And now I see you have retained counsel with you today, but I want to inform you, if at some point you are no longer able to afford an attorney, the court will appoint an attorney for you. Do you understand that?
Yes, sir.
Okay. I want to next explain how a probation violation proceeds. It roughly breaks into 3 parts. The first part is today, the arraignment. The whole point of today is to advise you of what you're accused of and to advise you of what the potential penalties are. I just told you what you're accused of, and in a moment, I'll tell you what the potential penalties are. You're entitled to have a contested hearing on this matter, and that hearing would happen within 14 days if you're in custody, but will happen promptly in either case. That hearing will be the second part, and that hearing would be like a trial, but it would be different from a trial in some important ways. First, unlike a criminal jury trial, there wouldn't be a jury at all. It would just be the judge listening to the evidence and making a decision about what happened. Second, unlike a criminal jury trial, the rules of evidence do not necessarily apply. What that often means is at a contested probation violation, the court will often allow hearsay testimony that might otherwise be inadmissible. Third, perhaps the most important difference is unlike a criminal jury trial, the burden of proof is substantially lower. At a criminal jury trial, the burden of proof is proof beyond a reasonable doubt, which is a very high standard. At a contested probation violation hearing, the burden is on the prosecution to prove the violation by a preponderance of the evidence. What that means is the prosecution has to prove this case, prove that it's more likely than not that the violation occurred. It's a substantially lower standard. If the court were to find a violation, either by your own admission or following that contested hearing, we would move to the third phase. And that third phase is sentencing. At a sentencing hearing for a probation violation, one of 4 or 5 things can happen. The court can continue you on your term of probation with the same terms and conditions. The court can modify your terms and conditions to make them more strict or less strict. The court could extend your term of probation to make it longer. The court could terminate your term of probation unsuccessfully, meaning you would no longer be on state supervision, but you might have negative consequences if you were to catch a future case. And finally, the court could revoke your term of probation and impose a term of incarceration. And that term of incarceration will be subject to the statutory maximum penalties on your underlying case. Agent Graham, are you able to state what the statutory maximums on this case would be?
Your Honor, it is 5 years for CCW. Your Honor, also, I would like to note the defendant is on HIDA status.
Okay, thank you for that addition. What that means, Mr. Pollack, is if a violation were to be found, you could be resentenced up to 5 years. But for you, it would have the added consequence of potentially revoking your HIDA status. Is everyone able to hear me still?
Yes, Your Honor.
Okay. What that means is it could also revoke your HIDA status, which means it would have the added consequence of turning your conviction into a real conviction. You understand all that?
You broke up a little bit, Your Honor. I understood it.
1 second, everyone. Mr. Pollack, were you able to understand everything that I just said?
Yes.
Okay. Turning back to the probation department, Agent Graham, our records are indicating there may be a new case related to the CCW. Is that accurate?
Yes, Your Honor, that is accurate. The defendant has new charges with 2 counts of CCW at 36th District Court under case number 2005-892902. He pled not guilty at a probable cause hearing on August 14th and was released on a $2,000 personal bond. He has an exam scheduled for November 19th, 2020 before Judge Giles.
November, that was November 19th?
Yes, Your Honor.
Okay. Am I correct? The probation department and defense both want this case to track the new case?
Yes, Your Honor.
Yes, Your Honor.
Okay.
I thought they put him.
December the 3rd.
Okay. We're gonna set this for a review date, December the 3rd. And that'll be in front of.
Yeah, if he's gonna be out, I don't know what it's out, which is out.
December 3rd.
Hopefully it will be open, but.
Folks, we're gonna set it for December the 3rd in anticipation that we'll be back to each judge running their daily dockets. So December the 3rd at 9 a.m. before Judge Chilinsky. And we're going to address bond as well. It's my understanding there's a $2,000 personal bond set in district court. We'll go ahead and set a $2,000 personal bond here as well.
Thank you, Your Honor.
Anything else today on behalf of the probation department?
Your Honor, please have the defendant provide his address and phone number.
Mr. Wallace, we can do this in a breakout room, or we can do it right here. Any issue with doing it right here?
No, Your Honor.
Mr. Pollock, can you please provide the probation department with your current address and telephone number?
8625 Brace Street, BRACE, 616-537-3511.
And your zip code, sir?
48228.
And who do you reside with at that home on Brace Street?
My mother.
Thank you.
Agent Graham,
Yes, Your Honor.
anything else on behalf of the probation department?
No, Your Honor.
And Mr. Wallace, anything else on behalf of the defense?
No, Your Honor.
Before we conclude, Mr. Wallace, may I briefly address your client?
Yes, Your Honor.
Mr. Pollock, I want to explain something to you. Your conduct earlier today was totally unacceptable. I understand the frustration you may have had with having to wait on Zoom, but I can tell you without a doubt, any other judge would have held you in contempt. Your lawyer can explain to you the significant pass that you got today. With that, we're adjourned.
Thank you, Your Honor.
Thank you, Your Honor.
Take care. Ms. Rhodes, I think that's the last case that we had today. There's some other items that are still on the schedule that got bumped to a different date. So I think that's it.
Okay, thank you. Have a wonderful day.
Right, you too. Take care.
Bye.